Hello, everyone. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at I.S. law firm. Thank you very much for joining our live stream. We have been offline for approximately a month, taking a break for holidays. It was a planned return to live streams, but it's also such a timing where I think our audience and our clients and all immigrants have a bunch of questions in relation to the recent developments, recent news. So I think it's perfect timing to return to our bi-weekly live stream on our YouTube channel. Thank you again for everyone who's joining us. Thank you again who shared this live stream link. Please press like, please share, please ask your questions. I will briefly summarize the recent immigration developments, including the news from the day before yesterday about the 75 countries being so-called banned from issuance of the visas. And I will answer all of the questions from our audience members. I see there are lots of questions already posted. I greatly appreciate it. I promise to answer every single question within next 1 hour or so. If we go over 1 hour because of the number of questions, we will do so. So I am, again, Ismail Shahtakhtinski. I'm the principal immigration attorney. I have been in practice of immigration law for nearly 20 years. Licensed attorney, member of American Immigration Lawyers Association. So during the recent time, as you know, during the second Trump administration, there have been multitude of changes to the rules, policies, and laws in immigration procedures. And so we'll touch upon, in the previous videos, in the previous live streams, we touched upon those changes that have been taking place up until approximately December of 2025. There have been some changes recently. I will summarize briefly as much as I can now. So without further ado, let's go directly to the point on the hot topic, the most recent news about the visa issuance ban. So the administration, the Department of State announced that the visa issuance will be frozen for the nationals of the 75 countries. Now, the visas, we're talking about immigrant visas. The word immigrant visa means it's visa for permanent residence in the United States only. It does not refer to non-immigrant visas. So I get a lot of questions about upcoming World Cup in the United States, and the questions are, how is the World Cup now going to be canceled? No. So for World Cup, any visitors who are coming into the United States, those are non-immigrant visas. The key difference in the wording between immigrant and non-immigrant. So non-immigrant visas are not affected. So you can still get your visa issued by the consulate if you applied for a visitor visa, tourist visa to visit World Cup, or student visa, work visas, O1s, and so on. So all non-immigrant visas. I know it's confusing, immigrant, non-immigrant, but that's a technical terminology. And, the Department of State is manipulating that wording to, create this chaos and confusion in the minds that all of the visas are banned and paused, where it's not all of the visas. So I made a very detailed video explainer the day before yesterday, the day this was announced. It's also on our YouTube channel, describing all of this in great details. It was a long video, long explainer, but I will not go into great details here now. But I'll summarize again that this refers to only non-immigrant only to immigrant visas. Non-immigrant visas are not affected. And it's not a ban. It's not an indefinite, although the administration calls it indefinite. It's indefinite from their standpoint, meaning they don't know when they will get to the point when they can reopen it. And what will take them to reopen issuance of those immigrant, meaning permanent residency visas at the consulates, is going to be when they refine the public charge rules. I'll explain what public charge means. So, well, let me go back. So the official reason that the State Department announced they're freezing issues of permanent residency visas, immigrant visas, through consulates, is because of the public charge rule abuse, meaning the public charge rules have been abused by the immigrants who are immigrating as permanent residents into the United States. They use public benefits for which they may not be eligible, or they're using taxpayer money to pay for their medical expenses, living expenses, and so on. And, granted, this has been happening, unfortunately, and many administrations, including Biden administration, including Obama administration, they've been trying to tackle this issue. And there are laws in the books to tackle the issue of public charge, which is when an immigrant is moving to the United States, when they're applying for permanent residency, whether it's inside the US or outside of the US, they have to provide evidence of financial means to pay for their living expenses for the next 5 years, which is usually the time by which individual becomes US citizen and they become eligible, or they have to have a sponsor, and it's called affidavit of support. So what the State Department, that Trump administration is saying they're doing is they're looking closer into refining those public charge rules to make sure that evidence of financial ability of the immigrant before they immigrate into the United States is sufficiently demonstrated. They'll take into account health considerations. There are rumors about weight of the applicant, that whether they're obese or not will be taken into account. That can translate to the health factor or not, depends on how obese, right? So, but that's not official policy. So they will look into it and they will reopen it. My estimate that these immigrant visas will be reopened sometime within 6 months, because if they don't reopen it within 6 months, the federal courts and the system will be flooded by magnitude of lawsuits by those individuals, Mandamus actions, forcing the State Department to make a decision on their immigrant visa applications. So what are immigrant visa applications? A lot of them are US citizens sponsoring their spouses, their children, their parents, or it's employer who's sponsoring employee. It's talent visas, meaning green card based on talents. All of those are frozen. So issuance is frozen. So there is a Administrative Procedures Act, APA, which says that the government has to process those cases within reasonable time. And that reasonable time begins from the date of the interview. So if you have an interview and those interviews must be held, must be conducted. So this freeze does not freeze the processing, although that's another misuse of the wording online on lots of headlines in the news, that the administration froze the processing of the immigrant visas, which is not true. It's not processing that is frozen, it is issuance. So that means the USCIS, the State Department, they still accept the petitions and applications. They still process those applications, and they still even schedule interviews. We have interviews coming up. We had interviews 2 days ago, and even after January 21. I'm not saying it's not possible that they will stop the interviews. They may, but then they'll be subject to a bunch of lawsuits in the federal courts, meaning the administration will be subject, and they'll have to use lots of resources to defend those lawsuits. Meaninglessly, because they will not have basis to defend, because we have such a thing. What's behind me on the wall here is a US Constitution. And by Constitution, the judicial branch of the US federal government has authority to order the executive branch to implement the laws, to implement the procedures. And it's in the Code of Federal Regulations that it's in the statutes that the administration, the State Department, must process the visas. They have no basis just because they have their mess of their own in handling and processing, or they don't know how to apply the laws. Or if they think there are not enough laws, then the president should propose Congress to enact new laws reinforcing the public charge rule. Again, it's not a bad thing that they're doing for the United States, trying to reinforce the public charge rules, but it's how they do it. They do it loudly. They do it loudly just like any other immigration enforcement that is currently done. And the reason behind it is to break the stereotype that has been created in the recent years, that the doors to the United States are wide open for anyone who wants to immigrate into the United States. Once you come in, you will be placed in the hotels. You're probably hearing this from President Trump and State Department, that during Biden administration, immigrants who crossed the border unlawfully without inspection, and after they were apprehended, they were placed in the hotels. That did not really happen. That's exaggeration. During COVID times, individuals who voluntarily approached the security checkpoints at the border and requested protection of asylum for the reasons of COVID quarantine were placed in the hotels, because the government and the hotels near the border, hotels, they were not like five-star hotels. They were placed there for the purpose of quarantine and for the purposes of determining their identity. That was the CBP-1 process. But prior to CBP-1 process, for example, during the Ukrainian crisis, when Russia attacked Ukraine, Ukrainians were being allowed, and they were taken in, they were placed and taken care of until they were able to freely leave and start and apply for their asylum protection in the United States, or for TPS, or for parole, and so on, until they were paroled into the United States. So all of this is done to break that stereotype. All these loud announcements, you see ICE officers in the streets. I'm not saying it's not happening. It is happening. The ICE does randomly arrest individuals in the streets who they believe is undocumented, or they target those who have criminal history. But the way they do it is they do it publicly, they do it demonstratively, they do it loudly, and they do it to instill the fear, to force some of the undocumented aliens to leave the United States voluntarily. And I have to be honest with you, it does work. We have lots of clients who contact us after they've been detained. We have individuals who came to the border and applied for asylum who are currently still in detention. And they're reporting to us that what they see on the ground in the detention centers, that lots of individuals who applied for asylum in the past, they are withdrawing their application and they're leaving the United States. So I'm not going to go into the politics of all of this, whether whether Trump administration is successful in securing the borders or not, whether how they're doing. But all I can tell you is that they're doing it recklessly, they're doing it loudly, and unfortunately, many law-abiding immigrants, many individuals who actually do deserve protection, many applicants who do have basis for asylum, or immigrants, general immigrants, even those immigrants who have permanent residence in the United States, who are well documented, they are suffering because of this reckless approach to this immigration enforcement. It's the way, it's the methodology, it's how Trump administration operates, and that's what we have to deal with. So regarding this ban, several frequently asked questions. Before even going through the questions, I will tell you that the ban does not apply to any visas or even permanent residency, change of status, what's called adjustment of status inside the United States. So that's number one to know. So it does not apply to those applicants who applied for permanent residency, who applied for adjustment of status in the United States. That's number one. Number two, it does not apply to non-immigrant visas. It applies to immigrant visas. Number three, there is a list of 75 countries that this ban applies to, and that list is on our website. You can see the post we made the same day. It includes the list of those countries. And I'll post it also here in the chat and in the comments of this live video, the link to our website post with that list. So it applies only those countries. Number four, this ban does not stop the processing of the cases. This ban, at least as it's been announced now, and at least as the government, the administration can do by law, does not apply to processing of the cases. It applies to issuance of the visas. So if you are planning to sponsor your relatives, if you are planning to file a petition for your relative, family reunification case for your spouse, child, or parent, or sibling, or if you are planning to file a petition for permanent residency based on extraordinary talents, national interest waiver, and so on, don't be discouraged by this news. Apply. The USCIS will accept your petition. They will consider your petition just as they did before, and your case will be processed. And those cases, to be honest with you, are currently taken about a year and a half to 2 years anyways. So if you apply now, by the time your case gets to the US consulate for an interview for immigrant visa, if you're doing it from abroad, again, inside the US, none of this information news applies to the cases inside the US. But if you're abroad and you're going through this process and you're sponsoring a relative who's abroad, and by the time they get to the consular interview, this issue is going to be resolved one way or another. Either the administration will lift it itself by finally, doing what they're claiming they're doing in terms of public charge rules, or the federal courts will order the lift of this ban. Now, I'll tell you what you can do if you had an interview. Some of you, or a few of you, may have had interviews recently, and you may be waiting for your immigrant visas, or your relatives may be waiting for immigrant visas, and now you're concerned, how long this indefinite, what does it mean? So, as I said, I estimate it to be not more than 6 months. If you had your interview more than 6 months ago, and your case is still in administrative processing, and that's where it will be per this freeze of the issuance of visas, if it's still in administrative processing after 6 months, you have a right to file action in federal court in the United States to force the State Department to make a decision under Administrative Procedures Act, APA Act. So that lawsuit is called Mandamus action, and we file it very frequently. On any given time, we have multiple mandamus cases pending. We file it in cases of asylum in the United States, forcing the USCIS to take action to schedule interviews. Many of you probably have heard that in the context of asylum, that you file it and the government immediately, meaning within approximately 3 to 6 months, they end up having to schedule interviews for those cases who have been stuck for years until the interviews, or in naturalization cases here in the US, or outside the United States for the consular processing cases, immigrant and non-immigrant visas alike. So those mandamus actions can be filed in the US in federal courts, and the federal court will order the State Department to issue the visas. So that's the recourse everyone has in case if this pause lasts more than 6 months. Now, the other part the other misunderstanding that I want to clarify is that the mechanism by which the federal government is pausing, not the federal government, but the administration, the State Department is pausing issues of visas, is not anything new. It's not a new pause. It's what is called administrative processing. And in the administrative processing of the visa issuance, well, let me back up and explain to you how it works. So the beneficiary goes to the interview at the consulate. They have an interview. And after the interview, the consulate says, "Thank you very much for all the information. We are not able to issue the visa now. We have to do some additional background research and gather information, and we will let you know when your visa is ready." Or they issue a list of things that they want from you to provide to them so they can issue a visa. Now, this has been happening for over a decade now, and that's called administrative processing. This has been taking place since 9/11. And the consulates often apply this administrative processing pause to the issuance of the visa in the context of non-immigrant visas, when individuals from the countries that either it's third world countries, or the countries which are suspect countries where there's been a lot of fraud and documentation and so on by the applicants, the government, the State Department, has been utilizing this under every single administration, including Biden administration, Obama administration, Bush administration, they have been pausing the issuance of the visas for administrative processing. And they usually issue a paper indicating that your visa is refused under 221G, and they indicate that they'll get back to you, or they ask you to provide the documentation. This is not anything new. Now, the visa refusal, that's another word that they're manipulating. So officially, State Department announced the day before yesterday that they have instructed in the memorandum, they issued memorandum instructing the consulates to refuse visas, right? And everybody's alarmed, refuse visas. So that's manipulation of the words. The refusal of the visa, it's a technical term. It does not mean denial of the visa. So the visa is not denied. It's refused for the time being. But technically, they only use this one word, refusal. So this has been this has been happening under prior administrations as well. But now it sounds loud, right? Because it's Trump who does it. They do it loudly. They do it, they create this panic in the minds of the immigrants and applicants, and even, U.S. businesses who are trying to employ foreign, highly qualified workers who they cannot replace, they cannot find here in the United States because of the shortage of the highly educated employees. That's the H-1B. That's another topic. You all know that the H-1B fees have been increased to $100,000 for the filing fee. That's ridiculous. There's been a federal lawsuit in relation to that, and the federal court did not pause this. I believe it's being now appealed, and I'm sure it's going to get to the Supreme Court that this 100,000 filing fees are too arbitrary. But I'm not going to go into the H-1B topic. The topic now is all this enforcement and all these visa freezes and so on. So you can file this mandamus action. What else you can do? You can write to your congressional representatives. Now, I'm not saying it will have a direct effect. So if your visa issues has been paused under administrative processing and it's taking too long, months, or even if it's weeks, you can start already complaining about this. But in terms of legal action, I wouldn't recommend to file a mandamus action earlier than 6 months after your interview. So do that. Now, what else you can do to tackle with these issues, with all these enforcement and problems with visa issuances and processing delays? File timely, file it correctly, accurately, make sure that everything is prepared and provided all at once. Whether you're filing an asylum application here in the US or you're applying for immigrant visa through a National Visa Center, through Consulate, State Department, make sure that you provide all the documents, you predict all of the issues that can take place. And for that, obviously, the best idea is to hire a professional to help you and assist you in this process. So filing it accurately, filing it timely, doing everything right from the beginning will put you in the better spot. So down the road, if the government is unfairly and unreasonably delaying the issuance of your visa, of your green card, you will have a right to file the lawsuit in federal court without fear that they will start picking on those deficiencies in your application. So doing it right and accurately from the beginning of the application is extremely important. And I always stress this in the asylum application context. Some of you who have joined, who are viewing this video or will view after the live stream, are joining us. A lot of you joining us because you either have a pending asylum application or you're planning to apply for asylum. Don't be discouraged by all the recent news about asylum. The asylum applications are being still accepted. They're still being processed. We have asylum interviews scheduled very frequently, at least several times a week. We have asylum interviews. I have 2 asylum interviews next week. We have asylum court hearings, and we're getting approvals. Again, don't be discouraged by all these news. Don't be discouraged about immigrating into the United States. The United States remains the country of immigrants, by immigrants, for immigrants, and United States is still welcoming immigrants. So no matter how loud or how contrary all of these news sound to you, again, the United States does accept immigrants. You can still file petitions. Your government must process those petitions, those applications, and the cases are being approved. The administration simply cannot. I don't know if they're trying to close it all or they're making it sound like this, but they cannot. All I can tell you is, again, because of the document that's behind me, the US Constitution, the government cannot do so. Cannot ban all immigration. In the first Trump administration, you've probably heard of the Muslim ban, right? So that was very popular. So the President Trump announced that they travel to the United States for nationals of all these. I believe it was 6 or more Muslim countries will be completely banned. And that did not work. Within weeks, if not days, the federal court ordered the lift of that ban. And since then, there has not been such a ban. Now, they're trying to clip things here and there, make it difficult, put obstacles. But again, the immigration system still works. It's open. Now, all of this, if we look at the big picture, what does all these problems, what does it all indicate? That, looking at the big picture, that we have Democrat government, Biden administration, who seemingly opened the borders. And being an immigration lawyer myself, protecting immigrants' rights and advocating for immigrants for 20 years, helping immigrants to immigrate into the United States, I have to honestly concede and admit that some of what Biden administration was doing was reckless. Individuals were crossing the border without detailed inspection, right? The idea of CBP-1 was that instead of forcing everyone to overflow and cross the border without being even identified and noticed, without any kind of inspection, why don't we open the CBP-1 process and force everyone, channel everybody through this one CBP-1 process, where at least we see their passport, we do background search, we vet, and we see who they are. But in reality, in practice, it did not work like this. We had, during the Biden administration, numerous clients from all over the world who entered the United States, and when I asked them, what did they ask you? Many of them were reporting they were not even asked the question. They just had their passport looked at and closed. Welcome. Here's the notice to appear in court. Go and appear in court, in an immigration court, to prove that you deserve asylum. That was not practicable way to do it. That was not, and that created a stereotype, and that's why we had hundreds of thousands, if not millions, of individuals in the world talking about coming to the United States for at least some time, because the border is open. Go across the border and you will be welcome, and you will be able to apply for public benefits or do some earning and so on. And I don't blame those immigrants who are doing it. It was not easy. The entire process, the most difficult part of it was not crossing the border, but arriving to the border. And those individuals were in dire need to do that. Nobody would go through 10 different, Latin American countries, infused with all these cartels and criminal groups and gangs, going through. Some of them went through horrific experiences to arrive the Mexican border. Those were individuals who were in severe economic distress or severe fear of persecution in their country, severe harm, whether it's war, whether it's their oppressive regimes forcing them to leave their countries. So unfortunately, these individuals, those were individuals, no matter whether they were filing for bogus, claiming asylum without basis and so on. I personally don't blame those individuals. I blame the system. The system is broken and it continues being broken. So that's why we have this roller coaster between two different administrations. So we have Biden administration that seemingly opened the border and said, screw it, everybody come in, we will find a way to deal with you here in the United States. From security standpoint, it was dangerous. Now we have Trump administration trying to break that stereotype and, loudly and publicly, seemingly, in trying to enforce, not enforcing. Again, Obama administration enforced detentions and deportations much more effectively than Trump administration in terms of the expenditures, in terms of cost, and in terms of numbers. To this day, Trump administration, based on my information, recent information, that still hasn't deported as many undocumented, dangerous security risk immigrants from the United States as did Obama administration. But they were doing it quietly. They were doing it effectively. Biden administration were almost openly, loudly, opening the borders and not as effectively enforcing the immigration laws. And Trump administration is trying to compensate for that and is doing it very publicly, loudly, and recklessly, and unfortunately with lots of casualties. Casualties in terms of families being broken, in terms of public panic, in terms of legal immigrants suffering, in terms of stereotyping individuals of Hispanic looks and of what do you say? Discriminating based on race, based on language, based on accent, and that is what is going on. But the reason behind it is, again, they're trying to compensate recklessly for what was going on during the Biden administration. So there is some truth when Trump often says, Biden, we had this, and Biden opened the border. There's some truth to that. And I want to be 100% crystal clear. My audience knows that when these news come up about these immigration enforcements and new announcements by Trump administration, you hear lots of headlines, clickbaits, trying to actually multiply the fear and so on. So they have more audience. That's not what I do. I always try to tell the truth. I always try to tell share my honest review and opinion of what is going on. And similarly here, I understand some might be upset that being an immigration advocate, immigration lawyer for so long, I do concede that Biden administration made a lot of mistakes, and some of these not mistakes, but intentional, reckless handling of immigration laws. And now we have reckless enforcement of immigration laws by Trump administration. But in the big picture, the problem we have, the United States has, is broken system. It's not the administration, because all administration does is enforces the laws. But the laws in the books are outdated. They are very outdated. They are, in some cases, they're so outdated that they're not even relevant to these days, right? So they create loopholes to use, but they also create loopholes for innocent individuals falling into those traps. And because of that, the entire country is suffering on both sides, those who are pro-immigration and those who are anti-immigration, right? So I don't believe there is anybody honestly anti-immigrant per se, but there's big chunk of the United States population that believes that immigrants are causing more trouble than benefit to the United States. Some of them do, some of them don't, and there is big chunk of U.S. population that is in between, and there is big, just like pretty much in everything in the politics, in the policies in the United States. So, bottom line, what I'm trying to say is that we need an immigration reform, and hopefully, people of the United States, the electors, and the Congress, as a result, will realize that this just cannot go through this roller coaster, and the immigration reform will finally be, enacted, and the laws will be modernized. They will have logical sense. There are so many laws in immigration. There are so many immigration laws in the books that don't make sense. They were enacted at one point, and then once they were applied, once those laws were enforced, it appears how ridiculous it is. right? So, and those laws are still in the books, and that's why we have these ups and downs. So we need an immigration reform, and hopefully it happens soon. But for now, we have to deal with these roller coaster of the laws. I'm here to clarify things for you. We have bi-weekly live stream. We're resuming now for this year. So 2 weeks from now, and in some instances, we may do in between as well live streams answering questions and clarifying all of these updates. So please subscribe to our channel and join. I will go ahead and answer all the questions asked. Now, we also post lots of video explainers, right? So again, regarding this recent news about 75 countries, nationals of 75 countries being visa issues being paused for the nationals of 75 countries, I made a very detailed explainer the day of the news, and it's posted on our also YouTube. Go there, comment, ask questions. We'll try to answer as much as we can. But in that video, you will see more detailed explanation what it means. But I've also tried to do it as detailed as possible. So unfortunately, most of this live stream was used to touch on this subject on enforcement, but that's the subject. That's what is hot now. That's what is in everybody's mind. So that's why we spend so much time on this. But you can post any questions you have. It does not necessarily have to be related to this news, and I will try to answer. And that's usually the format of our live streams. So let me see. Okay, the pinned message was blocking the first question. That's why I unpinned it. Okay, so the first question I have, please tell me about IR1 visa. Are they also pausing it? My case is now documentarily qualified since 6 months. Yes, IR visa is immediate relative one. So the immediate relative one is basically permanent residency for U.S. spouses or children or parents of U.S. citizens. And this IR1, immediate relative one, is an immigrant visa, and that's why it does fall. So it did not indicate which country you're from, but if your country is listed in among those 75 countries, then yes, your visa issuance will be paused. Now, you are documentarily qualified. To make it clear for other audience members, documentarily qualified does not mean you had your interview. Documentarily qualified means you are in queue for your immigrant visa interview. And again, I want to highlight, at least for now, the Department of State did not, and legally they cannot pause the processing. So they will schedule your interview. They will schedule your interview. And unfortunately, as I said, these processes have been taking long anyways, even under prior administrations, even before this news. So 6 months is not that long since you're documentarily qualified, meaning you provided all the information to the State Department that is needed to approve your visa and to schedule your interview, and now you're waiting for your interview. These interviews have been significantly delayed, and this delay is you cannot control it, basically. So I estimate that within several months or any time now, you may be scheduled for an interview, but unfortunately, the visa issuance will be delayed. If it's delayed for more than 6 months, service RCO, do contact us. We'll be happy to help you file a mandamus action in federal court, or you may be able to join a class action. So there are class actions going on. We're considering that as well, to join forces so that individuals like you who go through the interview and don't receive their visas, hopefully that doesn't happen to you. But if it does, contact us and we'll be happy to help you to push your case forward, to make the State Department to make a decision on your case. All right, so Amy Reaper is asking, since K1 visa considered non-immigrant visa, is that also affected by the 75 country ban? I'm asking for Colombia. So I cannot memorize the 75 countries. I assume Colombia is in the list. K1 visa is a fiancé visa. So the fiancé visa is technically considered non-immigrant visa. However, as part of the K1 fiancé visa, you still have to affirmatively prove that you're not subject to public charge, meaning your petitioner has to provide affidavit of support. It's a little bit different format, but you still have to do that and go through that public charge review by the consulate. So officially, they did not announce K1 whether it goes one way or another, unless it's happened like within some time today, and I'm not aware of it. But K1s are technically considered non-immigrant. So in the official announcement, K1s should be exempt if we just go word by word. But as I said, those words, don't take the headlines, even the State Department's own headlines or White House headlines, don't take it as technical meaning of those words. But in some cases you do have to take, as I said, it says immigrant visa, but many people don't know what immigrant visa means. But for K1, if we go into technicalities, it should be exempt from this pause. But if we go deeper and analyze that K1 also requires affidavit of support processing and public charge review, my assumption, my prediction is that K1s will be also paused. And to mention this, I haven't mentioned this during any of my videos, but the announcement refers to, the day this will be enacted, this pause will be implemented is January 21st. So if you have K1 interview now before January 21st, which is 5 days from now, you may still be issued visa now within these next 5 days, or whether it's K1 or immigrant visa. And what I recommend you to do also between now and January 21st, bombard the consulate by emails, send emails, do whatever you can to reach out to them. If you have bases such as, severe danger or fear of persecution for your family members or whoever is waiting for their visa, try to get the consulate to expedite, plead to them that please, until January 21, until this pause, please issue the visa. We understand, be respectful, express your understanding that the government has to enforce these laws, these public charge rules, and so on. But because of your situation, whether it's medical reason or so on, you have next 5 days for the consulate has next 5 days to issue the visa. And realistically, we have holidays, we have, unfortunately, Martin Luther King Day coming up on Monday. So I don't really know actually how consulates deal. They obviously they celebrate federal holidays. So probably the consulates are closed on Monday. So you realistically have only one day, 20th. The consulates have only 20th to issue visas. Whether they will rubber stamp and issue, I don't think they will rubber stamp, but they may, depending on the consulate, depending on the consular officer reviewing the case. They may sympathize, that they may help, and they'll have Tuesday to issue visas. For those, this only applies to those who already had their interviews at the consulate. I want to be clear to that, okay? All right, so as to K1, as I said, my personal opinion that it will be affected. But again, if it takes more than 6 months, contact us. Okay, Nikok Scales says, Salam, I've been in USA for almost 7 years. I'm 20 years old, had some family problems, so I had to figure out my documents myself. I got married. I'm going to submit I-485 during the interview. Should I tell them that I worked in USA previously? That's the only question I have. Thank you. It's a very good question. It doesn't relate to the recent news or the immigration enforcement, but it comes up frequently when one applies for permanent residence in the United States. So let me break it down for you. Since you're married with a U.S. citizen, you're saying you got married. I assume you're married with a U.S. citizen, and you're going through adjustment of status process. One of the most frequent mistakes is the applicants believe that if you worked without authorization in the United States, you will not receive your permanent residence. That's what mistakenly many believe. That's not true. First, you have to understand, working without authorization in the United States is not a crime. It's not immoral. In fact, it is moral if you had to feed your family and yourself rather than depending on the we're going back to the public charge, right? So depending on the public benefits for which you did not qualify. And in fact, in many types of applications, including, for example, cancellation of removal, I'm not going to go into details what it means, but in court, the judge evaluates your good moral character, and one of the questions is whether you've been working in the United States without authorization, whether you've been so that's a good thing from that standpoint of view. So working without authorization is simply a status violation, is a violation of your status. Now, in your case, you've been here 7 years, you did not have a status to violate anyways, so you worked, you earned yourself living rather than depending on the public benefits. And that's, I would present it as a good moral character to be able to do that. But the fact that you worked and it caused you status violation, you didn't have status to violate, so that's not a problem. But the fact that you didn't have status, that even if you did and violated that status, that still would not cause issues for your for your green card based on marriage, because you are an immediate relative of a U.S. citizen, and that's an exception. So usually, typically for adjusting your status in the U.S. or changing your status in the U.S., you have to have a status which you're changing, right? It's called adjustment of status. If you don't have a status, what are you adjusting, right? That's the question. But adjusting your status based on marriage with a U.S. citizen, or if you're a parent of U.S. citizens over 21, or if you're a child under 21 of U.S. citizen, that is an exception. So whether you had a status or not, or you violated that status by working without authorization, is not relevant. So NICOX scales, I understand you mentioned that you don't have financial means, so you're doing it yourself, and I admire that, but be very careful. Look deeper into your previous applications, look at your past immigration history, be very thorough. I don't want you to indicate something there that is not true in your application and be caught in lying, in misrepresenting information, because then you will be banned. So that's the issue. If you indicate that you never worked in the United States, and you've been here 7 years, right? For the last 7 years, you've been in the United States. Well, you are 20 years old now, so you've been 14, and probably your parents supported you. But if you worked without well, maybe not in your case, but in some other cases, applicants indicate that I've never worked, and then they go to the interview. The officer is not, they have normal logic, right? They're gonna question that. They'll say, you've been here this many years, you're saying you never worked, but how did you feed yourself? How did you sustain yourself? And this is U.S. federal government that has the strongest intelligence, at least we believe that the U.S. government still does, resources, strong, the best resources to dig, to do background search and to find. I mean, look at the records, arrest records, and so on. So it's not easy to hide. It's not recommended to hide that information of employment authorization. And in many cases like yours, where you're applying for permanent residency based on marriage with a U.S. citizen, it's not even needed to hide, even if it was legal to hide. But again, it's not recommended. Don't do it. Many get caught. They just don't share when they get caught. I always refer to this, that those who get caught, they don't tell, and that's why there is an impression nobody gets caught. But we immigration lawyers, we always have to deal with those individuals, and there are many people who get caught in sham marriages, in false information in their applications, visa applications, in the adjustment of status applications. So don't do it. It's not recommended. I'm not saying from the moral standpoint, all right? So that's not for me to judge. I'm saying from legal standpoint, you will suffer if you lie in your application forms and you provide false information. All right, how new rules is affected from I-730 asylee relative petition? So very good question. Asylee relative petition is asylum. It's not an immigrant status, okay? So that, again, since this happened 2 days ago, this announcement was 2 days ago, and it's not effective yet. It will be effective on January 21. How the administration will implement it nowadays is anybody's guess, right? So you all know that sometimes Trump administration says one thing and they do something. They say one way and then they do another way, and then we have federal litigation, federal courts ordering one way, and then we have appellate courts reversing it, then pausing the federal court's decision. Sometimes they don't reverse it, or they reverse it, but they don't pause the decision, or vice versa, and then it goes to the Supreme Court. So we immigration lawyers call it roller coaster of the rules and laws and changes. So we don't know, but at least based on my review and my opinion, it does not affect the I-730 relative petitions, because that's not an immigrant visa, that's not a permanent residency, that's a protection, that's asylum, and they cannot deny this. They can, well, again, they're not denying it, but they cannot pause this. Plus, pausing I-730 petitions can have dire consequences, right? Because a lot of those relatives are abroad and they are in the country where this asylee here in the United States have been granted asylum, and now they are bringing their relative, their spouse or children into the United States, and pausing that can have severe life-threatening consequences to those relatives and individuals there. So my estimation that it's not going to affect the I-730s. All right, next question. Is my K-1 visa affected by this, David? No, again, I answered this question previously. So how would this affect immigrants currently in the US applying for citizenship? It will not. It does not. It will not. Now, citizenship had its own change, and I made a video explainer on this. It's on our YouTube channel, and I believe we had one live stream about specifically addressing the changes in the citizenship process. Now, the changes are not in the laws. The changes are in the implementation, in the test questions being asked, in how the officers should look into the applications, what they should look closer into, and so on. So citizenship changes that have been paused on the issuance of naturalization certificates in the oath ceremonies, that for citizens, nationals of some countries, I don't have the list clearly in front of me, but citizenship itself went through the change in terms of test questions and in terms of affirmatively proving good moral character, starting from October 2nd, 2025, last year, just a couple months ago. So the rules that changed are that anyone who applied after October 2nd, 2025, must affirmatively prove their good moral character. I'll explain what that means. And the number of test questions to prepare for is 200 instead of 100. And 120, I'm sorry. The number of questions asked can be up to 20, and you have to answer 12 of them correctly. In the past, or for those who applied for citizenship before October 2nd, 2025, the number of questions to answer correctly during your citizenship interview, the test questions, is 6. So out of 10, you have to answer 6 correctly, at least. And now they changed it. You have to answer accurately 12 questions instead of 6 out of 20. But the total number of questions are 120. So that's been the citizenship change. Now, regarding citizenship, I do want to mention, considering all that is going on with these immigration news changes and these enforcement and so on, I'm often asked, is this a good time to apply for citizenship? Absolutely. This is the time when you should consider. And I made a list for myself that I share with my clients of the reasons why you should apply for citizenship this now without waiting. So yes, it's become more difficult. You have to affirmatively prove good moral character. They look closer into your past immigration history. They will consider every single application you filed. They will consider all of the information you provided in the past to see if you have inconsistency. So it's a very delicate process. But citizenship, it gives you a lot stronger protection than green card. You all have heard news since the beginning of the second Trump presidency where some green card holders, permanent residents, have been detained, and the government tried to strip them of the permanent residency. They did not succeed in many cases, but in some cases they do. They look closer, they find some technical errors in the past when they were applying for permanent residency and so on. They find reasons to pick, and they can't strip you out of permanent residency. And the worst part is there is So in the process of taking away somebody's permanent residency green card, the federal courts are not involved, right? So you do have basis. There are some ways to apply after you lose your permanent residency, trying to, not appeal. There is no standard appeal, but try to enforce this and so on. But to fix the issue. But in the process of taking away somebody's permanent resident status, the executive branch, the Trump president and those agencies, USCIS, and the Attorney General, which includes immigration courts, they can take away your permanent residency without necessity to apply for federal court, to federal court for that order, to federal judge. So the federal court, which is the judicial branch of the federal government, will not be reviewing that process at the time when the government is taking your permanent residency, because the immigration judge who will review it is not part of the federal judicial system. Many people don't know this. The immigration judges are immigration courts are creation of the Department of Justice of the United States. And the Department of Justice is Pam Bondi, right, the Attorney General, who reports directly to the President. Their creation of Pam Bondi's agency, Department of Justice, to test the decisions of the government agencies under the Department of Homeland Security, the USCIS, the State Department, and so on, through immigration court. An immigration court has jurisdiction on some things, and it doesn't have jurisdiction on some things. So the immigration judge is not a true judge, federal, in the sense that immigration judge is not a part of the federal judicial system. They're very respected. They're usually very highly qualified, but they're not part of the U.S. federal judicial system. And what's the problem with that? The problem is that those decisions made by the immigration judges can be controlled directly by the president through attorney general, right? So the immigration judges have to follow the precedents and the rules set by the Board of Immigration Appeals. Board of Immigration Appeals is also under Department of Justice, the U.S. Department of Justice. The Department of Justice, which reports to the Attorney General, Pam Bondi, which reports to the President, has control of the Board of Immigration Appeals. And the Attorney General can take cases and issue decisions, issue precedents, and force the Board of Immigration Appeals to make its decisions in reviewing the appeals from the immigration courts in accordance with what the Attorney General believes is the interpretation of the law. And then, obviously, the immigration judges have to follow the same rules. So if you're a permanent resident, you see how the system is prejudicial, right? It's almost conflicting. You're basically giving to the executive. I'm not saying it's wrong, because there is federal court review at the end of everything. But the beauty of being a naturalized citizen, or citizen born here, but we're talking about immigrants becoming citizen, is that here the executive branch of the U.S. government, the president, the attorney general, the Department of Justice, cannot take away your citizenship without having to go to the federal court and getting a federal judge, part of the U.S. judicial system, review their case and agree with them that you should be stripped of your citizenship. And they have very high burden of proof. So, for example, your green card can be taken away for technicalities, right? So, for example, you applied for green card and the officer at one point did not notice that the date when you applied was a bit too early, or you divorced before your application. So for technical reasons, they shouldn't have approved. Down the road, when you apply for citizenship many years later and so on, they can, or for any reason, the government can reopen your permanent residency and they can take it away. And you're not going to be able to do anything about it. So it's very fragile to be a permanent resident nowadays, or in general, because taking away permanent residency. But denaturalization, you all have heard probably, again, Trump administration loudly speaking about denaturalization and so on, that we're denaturalizing this and that. That's not true. They cannot denaturalize. It has to go through federal courts. They do it, but they have been doing it under prior administrations as well. On the Biden administration, Obama administration, and so on. First Trump, and so denaturalization requires a significantly higher burden of proof that there was a clear fraud in the process of applying for citizenship and permanent residency, and this has to be proven. It's not beyond reasonable doubt, but I believe it's clear and convincing evidence to denaturalize. It's so rare that there is very rare cases of someone being stripped of their citizenship, and the government, they don't even have resources to do that. So anyway, bottom line, what I'm trying to say is that if you're a permanent resident, you qualify for citizenship, do it now, don't wait, apply for citizenship, protect yourself. It's like you are in a war zone and you don't want to, get a armor for yourself, right? Citizenship is your armor so that you're not fragile. The other part, right? So they're doing, Trump administration announced vetting individuals for their America or anti-Americanism, right? So what will happen down the road, nobody knows. What they will try to do, nobody knows. But if you're a citizen, you'll have a lot more protections, a lot stronger layer of protection. You'll be in a bunker versus, with some kind of protection in the field during the war zone. So apply for citizenship, go through the citizenship and prepare very well. Make sure when you apply for citizenship, you prepare everything very accurately. You review all your prior immigration history, all your prior applications, go through the details. If you had a lawyer in the past, obtain your copy of your file or go with that lawyer if you trust that law firm. If not, it's always highly recommended to retain a law firm, and we'll be happy to help you. Again, I'm not trying to sell my services here, but maybe partially we do. That's business, right? So everybody tries to advertise their services. Not going to hide that. But in this context, what I'm trying to say is that don't do it yourself, right? So you're applying in this day and age, you're applying for citizenship. Definitely do. Don't be discouraged by all this and try to hide and not apply for citizenship. Do apply for citizenship, but do it right. I always tell my clients who ask me this question or audience, if I need to build a house, nobody forces me to go and hire someone, right? So if I need to treat myself, I have medical condition, there is no law forcing me to go to a doctor, but I do it because I'm not stupid, right? I don't want to make a mistake and then cause severe permanent injuries to myself or even life-threatening situations. So similarly here, right? So nobody forces you to hire a lawyer, but it's a right thing to do. It's a good thing to do, but not only hire a lawyer as a check mark. Oh, I have a lawyer, that's it. No, you want to do vetting. You want to research, you want to find out about that lawyer or law firm you're hiring. You want to look into their background. You want to look into what others say, look at their reviews, look at their experience, look at their knowledge, talk to them, follow them, see if you feel comfortable, right? Somebody may be a really highly skilled, very knowledgeable person, but then you may not feel comfortable working with them. There may not be this chemistry. So talk to them. Lots of law firms, including us, we have free initial consultations where we do discuss briefly the case, and we do that. Anyway, let me stop on advertisement here. So citizenship, if you're qualified, apply, don't wait, and work with a highly competent and qualified attorney law firm to handle this. Does your cooperative agreement apply to Afghans? Asylum cooperative agreement. Dunya, I'm sorry, I don't have that much information about the asylum cooperative agreement. Whether it applies to Afghans, I'm sorry, I don't have that. I don't want to give you false information. I will look into it. You have links on our website. You have email address law@islawfirm.com. If you want to send that question there, I will be happy to look into it. I think that's good for me as well to know this cooperative agreement, whether it's something new, that whether it applies to Afghans or not. Okay, Hi, I had a pleasure of speaking to Gunel yesterday and told her how much I enjoyed your video yesterday. Well, thank you so much. Thank you for your comments. This viewer is referring to the video explainer that I made after this news about the 75 country visa issuance ban. So watch it, please. We'll post it here in the comments as well, the link to that video. Next, hello, Ismail. Can you or your company help me with asylum case dismission in court so I can leave USA to proceed with consular processing based on an approved EB2? Yes, of course. We'll be happy to talk to you. So what this viewer is asking is they have a case, asylum case in immigration court, but they also qualified, I assume you have the approved petition EB2, and you went through the NVC process. So first I want to mention that you don't have to now dismiss your case or apply for voluntary departure, close your case to go through the consulate at this time, because there is a lot of processing before you have your visa interview, which is called NVC, National Visa Center processing. So go through the NVC process. It will take many months, if more than, in many cases, more than 1 year, until the NVC receives all the necessary documentation and so on. And then they forward the case to the consulate and put you in the queue for the interview. And then you will wait for the interview date. Once you have the interview date scheduled, then if your case, well, since your case is in immigration court, you cannot apply for advance parole. If you had a pending affirmative asylum, we usually apply for advance parole, in which case you don't even lose your asylum case. You basically get a permission to temporarily leave the US, go through the consulate, get your permanent residency visa, immigrant visa, and return. But in this case, as you know, now the immigrant visa issuance is paused. So that's also a precarious position that if you have an immigrant visa interview, should you go or not? Because you know that you're going to be probably stuck there abroad for months. Where in the past, we had many clients for whom we went through the immigrant visa interview with advance parole, and then they returned basically within weeks after the interview. So yes, we can help you. Get in touch with us. I'll be happy to talk to you and see what we can do to help in this current situation. That you may be qualified for voluntary departure. Voluntary departure in immigration court means that you are getting permission from the court to withdraw your asylum claim or whatever relief you applied for, and get the permission from the court to leave from the immigration court, from immigration judge, to leave the United States on your own basis, on your own time, and voluntarily, and they usually give you 120 days to do so. Now, there are specific requirements to qualify for voluntary departure, so you want to analyze this very carefully. You don't want to apply for voluntary departure and then be denied of voluntary departure, and that it leaves a little bit of dent, if not strong dent, in your asylum claim. And then you pursue your asylum claim, and the judge looks at it. Well, you already applied for voluntary. You said you can leave the United States. Now, by your name, I believe you may be a citizen of Azerbaijan, and if you are, your immigrant visa interview is going to be held in Georgia, Tbilisi, which could be a good argument for you to say that, well, I'm not going to Azerbaijan, I was going to go to Georgia. But anyway, long story short, if your case is in immigration court, you probably have an attorney. Talk to them. If not, if you want me to take over the case, contact us. We'll be happy to help you. That's another issue, is the third country processing. They made it tougher now. So for asylum applicants who qualify for permanent residency based on other bases, such as employment, talent, national interest waiver, in this case, I believe is what you have, those applicants, they also have this dilemma. If they withdraw their case and they go for the interview, to their own country, home country from which they applied for asylum, that U.S. consulate in that country may be questioning them. How come you applied for asylum, saying you couldn't return to your country? Now you qualified for a green card based on employment, and you voluntarily returned to the same country from which you applied for asylum. So did you lie? Did you misrepresent? Was that a frivolous asylum application? So make sure that those questions are properly analyzed and addressed beforehand. You don't want to risk for it. Many people have an explanation. Depending on the basis of asylum, you may have an argument that I can return to my country temporarily for a brief visit for that visa interview, But the reason I applied for asylum, it's one thing to live here, to go through what I'm going through, and it's one thing to briefly come and visit. But if you've been arguing that you will be detained if you return because the government is, chasing you, that you have a criminal case, and then you qualify for a green card on other bases, and you quickly withdraw your asylum and leave the U.S. and go back to your country, yes, you're not going to have a 10-year ban of deportation order, but you will have that presumption in the minds of the officers at the consulate that, hey, this doesn't go away. You applied for asylum. You told us that the government of your country is looking for you. Now, the other issue to address in this type of processes where you had an asylum case, now you want to withdraw and go back and go through the process, even if you go to another country. The other issue, major issue, is the information you provided when you filed for visa. So many applicants apply for a visitor visa, student visa. They come into the United States and then apply for asylum, right? So they may have perfectly legitimate basis to do so. Now, in their initial visa application, they indicated that they have not been arrested, detained, or charged. But in their asylum application, now they have a story that they've been detained, charged, they've been, arrested in a protest or by their oppressive regime of their country and so on. They have bogus criminal charges against them, and here's the documentation, or they may even have Interpol search. So Interpol red notice. So with that, in the context of asylum case, the fact that you misrepresented that information, meaning in your DS-116, your non-immigrant visa application, when you applied for a visitor visa, you did not indicate you've been arrested in your country. That fact is excused. I say it figuratively excused, but basically there is a law which says that the fact that you misrepresented information to escape from persecution, to save yourself, your family, your freedom, your well-being, that is not basis to deny asylum. But that is basis to deny your permanent residency based on your employment-based petition, on your national interest waiver, EB2, or talent, EB1, or even family basis. So that's what many asylum applicants run. The issue that many applicants run into is that they apply for asylum, they indicate what happened to them in their country, which should rightfully do so. I'm not saying hide that information, but then, and in the context of asylum, the fact that they did not indicate that in their previous visa applications in the past is not a problem. But then they get married with U.S. citizens, and they get sponsored, and then they apply for adjustment of status here in the U.S., or they go through U.S. consulate abroad. And in that context of obtaining permanent residency, not based on asylum, but based on the adjustment of status with the marriage with a U.S. citizen, whether you at one point misrepresented information either at the border or at the visa application becomes relevant. That makes you inadmissible into the United States, even though you're married to the U.S. citizen. So false information, misrepresentation, using of fake documents, and so on will make you inadmissible. There is a waiver process for that, where you can apply for a waiver, but that's a very burdensome process. It's a difficult process, it's a costly process, and it will make your case last much longer. So make sure all of this is reviewed, planned ahead, and if the waiver is needed, then the waiver is needed. You need to apply for that waiver. If you're going through consulate, you may need a waiver, I-601 waiver of misrepresentation basis of inadmissibility through consulate. It will prolong your case. It will make your case much longer. So schedule a consultation. I don't think, I'll tell you up front that this is not a quick free consultation you want to schedule with lawyers just to get quick random answers to your questions. You want your case to be very thoroughly analyzed. So schedule a full consultation, whether with me or any other competent lawyer that you're comfortable with. Make sure that you fully understand what to do. There are lots of twists and turns. It's a very delicate process. Once you apply for asylum, everything about your future immigration, whether it's going through the same asylum case or switching to some other case, becomes extremely delicate, extremely nuanced. So don't just run for check mark to work with someone who may not even be licensed attorney and so on. And don't try to do it yourself. Make sure you have qualified legal support. Okay, next question. If a child and only the child is on Medicaid for health insurance, currently green card holder, would that have been considered a public charge? So they have not rehashed, they have not clearly defined, identified all of the public charge issues, at least public charge factors. At least as of now, to answer your question, typically not, but it's still a factor. So public charge basically gives that discretion to the officer, whether they're considering adjustment of status or at the consulate. The public charge rule says, determine if this person is more likely than not to become a public charge in the United States, meaning depend on the public benefits and so on. So if you used public benefits such as Medicaid, and you are the child is a green card holder, then that becomes a question, right? So the child or whoever has been to become a green card holder, the person have been sponsored probably, and they had to have a sponsor who filed an affidavit of support. The question is, what happened to that sponsor? Technically, the U.S. government can pursue compensation for those Medicaid benefits paid out to your child green card holder from the sponsor who signed I-864 affidavit of support with the U.S. federal government saying that I will compensate you. Many people don't understand the affidavit of support I-864 is a contract between the sponsor who's sponsoring the immigrant to permanently move to the U.S. that promising to the federal government that they will make sure that this individual does not need public benefits for whatever the reason. And typically, emergency medical services are excluded, but there are lots of nuances. I don't even have that from this formula, what is included, what's included, not included. So anyway, bottom line is permanent resident, public charge at this time, if your child is going through citizenship process. But again, they don't have to. I mean, if your child is under 18, they don't even have to apply for citizenship. If you become a U.S. citizen, then the child is going to become a U.S. citizen under 18 automatically. So anyway, bottom line, consult. It's not an easy answer whether it does. It is a factor. It's going to create a question, but it's not, and at least as of now, it's not going to cause a denial. All right, next question is, hi, Mr. I have an ongoing Mandamus lawsuit, and one thing you want to ask, will it affect my case regarding this new travel ban? No, well, depends on Mandamus lawsuit for what? Is the Mandamus lawsuit inside the United States for your asylum case, which is most frequently filed, or naturalization case? In that case, no, absolutely, this is not going to affect. If it's a Mandamus lawsuit related to the visa issuance, then it means that you already had your interview and your visa was stuck in administrative processing already. Basically, that's what exactly will happen to those immigrant visas based on this new announcement. So if you already have your immigrant visa stuck in the processing or administrative processing or non-immigrant visa, and you filed Mandamus, no, that's not. So that's not going to affect. The Mandamus lawsuit is a lawsuit filed in the judicial federal court, in the judicial branch of the government. So that means the president cannot change those laws, at least for now, thankfully. Different, again, always point out, because of this document, behind us, the Constitution of the United States. It doesn't have all the amendments, but it has the first articles of the Constitution. So, but because of that, the president cannot change what the federal courts, what the laws, the acts that this Congress enacted, how they are implemented. The Mandamus action filed in a federal court is a federal case that you file in the federal judicial system, and only the federal judge can decide that the president, the administration, the State Department, they can argue, but they cannot, unilaterally change these laws. Okay, so no, I think your Mandamus lawsuit will go the same way, and it will process the same way. I had a Mandamus status hearing on a Mandamus case that we filed in an asylum case last week, and we had a status hearing where the government was asking for extension. Government meaning the attorney that represents the U.S. government, the Department of Homeland Security. They were asking for extension to file an answer to our complaint. We already agreed the interview has been scheduled, but we're keeping it live because currently the U.S. government paused the decisions on asylum cases, right? So the decisions on asylum cases have been paused. That's another news, again, because of this visa pause being so, loud and alarming. We dedicated all of this to that, but that's entire another topic. So the decisions in the asylum cases have been paused as well, meaning recently. So the government is not deciding, issuing decisions, but again, that cannot be indefinite. So we filed in that case, and I had a status hearing with the judge. It was telephonic hearing, and the judge was really angry at the government. They're saying, "Why do you need this extension?" And the attorney representing the U.S. government was saying, "Well, because President Trump announced pause on the Department of Homeland Security announced pause on the decisions on asylum cases," and the federal judge was, I don't care. I mean, he wasn't saying necessarily that way, but the bottom line, it was like, I don't care. No, it's your problem. You're the executive branch. You have problems in processing cases, or you think you should do this pause to effectively, but it cannot cause changes in the procedures of the federal courts, where now I, as a federal judge, have to give you 90-day extension for you to respond to the lawsuit filed by I.S. law firm, simply because President Trump announced that he pauses decisions on the asylum cases. So I'm just saying, not from theoretical. The reason I'm sharing this with you is also from practical standpoint. This is what's going on, this constant struggle. Now we're keeping that case alive, even though the asylum interview has been scheduled, because we are anticipating, and I argued that to the judge, the reason why the case is not settled is because there will be interview, but the government itself is saying that we have indefinite pause on the decisions. And under Administrative Procedures Act, they cannot indefinitely pause the decisions on asylum cases. They have to keep processing those asylum cases and decide within reasonable time, because the U.S. Congress enacted this law, because the government because the administration of the President Trump, they are tasked, they are forced, they are required to implement those laws, those procedures. So they have to consider. Anyway, bottom line, so mandamus lawsuits are going, and you should file mandamus. Anybody who has a case, you had an asylum interview and haven't had the decision, or your interview has been stuck for years, typically we say more than 2 years, you can file a lawsuit in federal court and have your interview scheduled soon, typically within 3 to 6 months. We do that. We work on these cases almost every day, and contact us and we'll be happy to help. All right. How does it affect K1 visas from partially banned country? Legal professionals are all giving conflicting info on the government website. It's a non-immigrant visa. Yeah, so I answered this question, and I appreciate so many of you have that question, and it is a legitimate question, because K1 is kind of hybrid type of visa. K1 is a fiancé visa. So once a U.S. citizen wants to get married with someone abroad, and bring them as their spouses into the United States, they file a petition here with the U.S. Citizenship and Immigration Services under the Department of Homeland Security. The USCIS reviews the petition and approves, and then sends it to the consulate, and the consulate schedules an interview. The fiancé, who is not yet married with a U.S. citizen, receives K1 fiancé visa. And with that fiancé visa, they enter the United States within 6 months after the interview, after the issuance of the visa. And then they have to get married with a U.S. citizen within 90 days. You all have heard probably 90 Days Fiancé, right? The show, the popular show on TV. 90 days, that's where the 90 days come from, technically. And a lot of those fiancés in that show are foreigners. Well, maybe not a lot. I didn't follow the entire show. But so the fiancé visa is that. So then they have 90 days to get married, and then after marriage, the fiancé now can file for adjustment of status, become permanent resident in the United States. So the question that is coming up so frequently is whether fiancé visa, will the fiancé visas be banned? Will the fiancé visa issuances be paused under this new announcement? The answer, again, under my opinion, that it's not. Well, no, I'm sorry, vice versa. The answer is that technically it should not, because it's a non-immigrant visa, but because if we look deeper into the officially announced basis for this pause, which is the public charge rule enforcement and refining and vetting for public charge, the fiancé visas are subject to public charge rule, meaning the fiancés of U.S. citizens, when they go to the consulate, they also have to provide affidavit of support. The petitioner here has to provide affidavit of support and evidence of their financial means to support that fiancé, because that fiancé is moving to the U.S. with intent of permanently remaining here, marrying with that U.S. citizen, and that U.S. citizen has an obligation to the taxpayers of the United States to prove that, hey, I'm bringing my fiancé to the US, I'll marry, and he or she will stay in the US permanently. Don't worry, I have enough financial means to support my future spouse, so you shouldn't worry about it. That person is not going to depend on you. She or he is on me. So that's what public charge means. That's what the affidavit of support means. So because fiancé visa does have that element in it, it's my opinion that the fiancé visas will be affected, unfortunately, as well. But again, if it gets stuck for more than 6 months after the interview, not the processing, because the fiancé visa processing takes time. It takes about year 12 to 18 months now until the visa interview is scheduled. So, but if after the interview it's stuck for more than 6 months, get in touch with us. We'll help you. You will be eligible to file a lawsuit. Now, the Mandamus lawsuit in court, I keep saying you do this and that. It's not cheap. So Mandamus actions in every case has its own different, basis, different reasons. Every case has different pricing. It's not one shoe fits all. But I'll tell you roughly it's anywhere between 3,000 to, in some Mandamus cases, it can cost 10,000 or so to file this, but it does yield results. So, maybe 2,000-3,000 versus 7,000-8,000 and so on, just to have a rough idea. In most cases, it's somewhere in between those numbers. Okay, next question. NVC family interview on the 14th and consul visa said visa approved at the time of interview. Nevertheless, passports are not handed yet with the visas. Does the current ban policy affect visa in this case? It does. It does on the 14th. I assume you mean 14th of this month. It does, and it will after January 21st. Now, I think your case is a very good candidate for pleading with the consulate that, hey, before this ban goes into effect, unless the beneficiary is from the countries, 39 countries out of the 75 that have already had this issue, this ban, this pause, right? So there have been 39 countries previously announced in December going through the similar visa pause, and the 75 countries that have been announced include those 39. That's another reason I am, confident and sure that the President Trump's administration is announcing this knowingly with this loud and with manipulation of the words to create the fear and chaos and panic, or to show their allegedly tough immigration enforcement. Because instead of saying we had 39 countries, now we're adding 36 to it, right? That equals 75. They're saying announcement is 75, but other 39 were already there. Partially, there is 19 of them that had full ban, non-immigrant and immigrant, 19 countries. The list is online, you can find, and then the remaining 20 had less. It was technically 38, including one Palestinian territory. So, if you are not one of those countries, if you had 14th, you still have a chance. Maybe Tuesday, the consulate can issue. It's not very likely. I don't want to give you false hopes. But if it then gets stuck for more than 6 months, you can file a mandamus lawsuit in federal court. But unfortunately, I cannot give you good news that it does not fall. It does fall. If your country is listed in 75, then it does fall under that, and it will be affected by this visa issuance pause. Will this pause affect anyone who were already issued immigrant visas from their country and will travel to America for the first time after the 21st of January? Excellent question. No, it does not. It does not include that unless the visa is terminated. Revoked, but they have to have legitimate reasons. Now, all I can tell you is how it should legally be. But how will the Trump administration change their mind and try to revoke? We've heard about a lot of the F1 student visas being revoked. I believe the last figure was 100,000 F1 student visas have been revoked that have been previously issued. But in F1 context, in non-immigrant visa context, the consulates and the government have wide discretion to decide, because one of the huge factors in F1 is immigrant, non-immigrant intent. That somebody who applies for a student visa or a tourist visa, they have to demonstrate to the consular officer that they're not permanently planning to remain in the U.S., and the consular officer has to determine in his or her mind whether this person is telling truth or whether this person will return to their home country, whether they have close ties, and those factors are very blurry. So a lot of it is what the consular officer's mind decides, right? So the consular officer may like somebody's face or looks and sympathize with someone. They may have good mood, bad mood. Now, for immigrant visas, that's not the case. For immigrant visas, the rules are stricter, and the consular officer doesn't have as wide of a discretion to make a decision, because for immigrant visas, again, permanent residency, they cannot revoke and say, well, the previous officer made a mistake. We believe you're going to stay in the U.S. permanently, where you told us that you're going to study in school, or we found that the school is fraudulent, and so on. So revocation of immigrant visas is very rare compared to non-immigrant visas, and that's why I wouldn't worry unless you know things that you should be worried about in the process of applying for immigrant visa. If you already have your immigrant visa in your hand by January 21st, then this pause on issues of the visas this news about 75 countries does not affect your case. You can enter the United States. Be careful that immigrant visa in your passport is only valid for 6 months. Don't miss that. If you miss it, then you miss it. That's it. Then the whole thing has to start all over again. There is no extension. So once you have your visa in hand, make sure that you look into the expiration date. You have to enter the US within those 6 months. Once you enter the US, you will receive your permanent resident card, green card, in the mail within several weeks, in most cases, sometimes several months. But you also have to pay the immigrant visa fee once your visa is approved, and you have to pay that fee so they produce your green card. Also, if you don't receive your green card in the mail after you enter the United States with that immigrant visa stamp in your passport, if you don't receive your green card in the mail, you can file an inquiry. At the same time, many people don't know this, that visa stamp in your passport acts as a substitute for your actual green card for at least 1 year, and it can be extended. So if you enter the United States and you need to leave, okay, so as long as you entered within those 6 months, you registered your permanent residency, your green card will arrive in the mail. But even if it didn't arrive, you can technically leave the next day to return to your home country to do whatever you had to do to wrap your affairs, your business, and so on, whatever you have there, right? So you need to, during those 6 months, the requirement is you need to come and register. As long as after you depart, you don't get stuck there for more than 6 months, because then you're going to have problems. And if you watch our videos on the absences from the United States while being a permanent resident, you can get all the information. There is a reentry permit you can apply for to be eligible for absence of up to 2 years without even having to return to the US, where you will not lose your green card unless for any other reasons other than the length of your absence. So there are ways to be able to be absent from the US. Watch those videos. Again, reentry permit, go to our website. That's another reason to subscribe to our channel, is that we post these videos, explainers, information, news to be up to date on top of all the news. Subscribe to our channel. We promise not to bother you with anything ridiculous. It's all relevant, only the hot topics. Like this video, like this live stream if you think that it's helpful. If you don't think that's helpful, don't like it. I believe YouTube has a dislike button as well. So do that and watch that video. After you enter the US as a permanent resident, God willing, you will. it doesn't end there. You still have to maintain your permanent residency. That's another reason to apply for citizenship. You don't want to delay this. Apply for citizenship as soon as you qualify for this. Don't delay. Okay, next question. Can an Afghan who is currently at the Mexico seek asylum in the US border? Very limited, but it's still possible. Now, if the differences are the way the enforcement works. So in the past, they would process and let you in. They would parole you, especially Afghan citizens. Now that applicant is most likely going to spend months in the detention until sometimes even over a year, until the case is decided. Now, somebody may say, well, there is Habeas Corpus Act. It cannot be more than 6 months. It can, as long as you applied for asylum and your case is pending. Then the clock for the 6 months before habeas corpus does not start. It does start doesn't start until you're ordered removed from the United States, and the government cannot remove you. Then spending too much time in detention becomes punishment rather than enforcement of immigration laws, and that's the basis of the habeas corpus, is that the individual should be released or deported. If the US government cannot deport them, they need to release. But the reason I'm saying is all of that is something that the Afghan national who comes to the US through the Mexico border to apply for asylum needs to know beforehand, because that's the reality today. They will have, and they may not be eligible in most cases now for bond. They may not be released on bond. So let me go through. What about K1? Again, I appreciate so many questions about K1. I understand there is a lot of fiancé visa applicants. I believe I've answered that very thoroughly. I had the interview 13. I applied using another citizenship that is not banned. Oh, okay. So you have two country citizens. My wife has only one citizenship, which is banned. I believe I have an exception. Does my wife has an exception as derivative? There is no information yet, at least information that I've seen, about this type of situation. One spouse is a citizen of one country, which is in the list. One spouse may not be citizen, maybe citizen of the country that is not in the list of this pause. First, the announcement, I believe, said that there are exceptions, but I don't know if this specific. I would assume that there is, good reason to apply for that exception. But, presenting evidence of sufficient financial means and, good evidence of support, financial support, I think that will help, in addition to the fact that you're exempt, but your wife is not. Is among those, her nationality is among those 75 countries. I think that could be a good reason to apply for that exception. I don't know if it will work. Again, in practice, it hasn't started yet. It's on the 21st. But if you had an interview on the 13th, you still have a chance. So push, bombard the consulate, see if they will do something. Maybe they will plead to them. All right, because they have, again, Tuesday, the 20th is the only date, or today, but it's already too late probably for the consulates to do any actions. They may approve some of the visas today. Okay, please someone answer my question. That someone will be me. Sponsor my fiancé visa. Am I getting affected by that? Okay, yes, same question about fiancé visa. I hope me being that someone, I answered that question thoroughly. Sorry about being sarcastic, but if you still have questions, if you still want to talk about it, please feel free to contact us. We'll be happy to help. I filled I-130 2 years, still in process. Are they going to stop the process? No. Very good question. I hope I made it clear, but I'll repeat, and that's a good question, and I like that you're asking it again. The process does not stop, at least under this announcement. So it does not. And at least legally they cannot. So legally they can use this administrative processing within reasonable time, and that reasonable time is typically up to 6 months, and that's what they're going to utilize. But they cannot just stop the processing. Let me tell you this. They even tried to stop the processing of diversity visa lottery visas, and even there, they've been partially forced to issue some of the visas. Now, I'm not going to go into it not for some reason, but for some technical legal reasons. Those lawsuits Some of them, most of them did not go anywhere. But what I'm trying to say is that under Administrative Procedures Act, the government must process cases. They also must make decisions within reasonable time. They cannot pause the processing of the cases. None of these announcements about asylum and so on affect the processing. It cannot. Legally, it cannot. So it affects the processing of the approvals, the issues of approvals, or issues of the decisions, or issues of the visas. So no, the process does not stop. And if you filed I-130 2 years ago, depends on the type of I-130. I-130 is a petition for relative. If you're sponsoring if you're a permanent resident sponsoring your spouse or child, just I-130 itself with the USCIS will last probably 2, 3, 4 years. And then you have National Visa Center processing, then consulate. Long story short, if your I-130 is currently pending as of today, you have to worry about the USCIS not processing it timely, well, delaying it. So deal with that. But this announcement, this visa issuance, that's not going to affect your case at all, because by the time your case goes to the consulate for the interview, this pause or ban, whatever they call it, is not going to be there. I mean, maybe they'll come up with something else to put more obstacles. Hopefully not. Based on I'll tell you something else in the big picture. Based on the way they did during the first Trump administration, of course, many things changed. They were rookies during the first Trump administration. They did many things without legal foundation, and that's why a lot of those executive orders were just stricken right away. Similarly to the executive order under this administration, during this presidency of Trump, when he issued the executive order immediately about U.S. citizenship by birth, right? So again, we have it in this document, not this one, but in the amendments to the Constitution, that somebody who's born in the U.S. becomes a U.S. citizen by birth. That's it, period. No exceptions, no excuses, and so on. Somebody who's born on U.S. territory, on this land. So there is an exception if it's a child of diplomat, because they are not considered here. That's why they have immunity. So we're not going to go there. But U.S. citizen, somebody who's born in the U.S. is born. So Trump, during the first day, I believe, of this presidency, issued an executive order, and the federal court immediately struck it down, and that didn't work. So during the beginning of the first 2 years of his presidency, during the first presidency, the 2 years, they did all these things. They tested the boundaries. They, tried to enforce, come up with, issued a bunch of executive orders. They hit their head on the wall, and then they stopped. And I believe that's what they're doing, and we're kind of in the peak of that, testing the boundaries by now this presidency. This time they're doing it a little bit smarter, still reckless, but they're doing it louder. But at the same time, they are trying to build the legal foundation before the ridiculous executive orders and bans and pauses are issued. But yeah, eventually it's going to calm down. The dust will settle. I usually, as I said, I expected the peak to be upon the first year of the presidency, which about where we are now. And then will start gradually receding. Again, that might be naive, too optimistic belief, but I'm just basing it based on what we saw during his first presidency. Or maybe peak is going to be somewhere down the road, but then eventually it will recede. And then, I'm not saying everything is going to be normal. There will be a lot of these type of issues, and testing boundaries and reckless executive orders, which will be struck down by the courts, but at least not to the level that we're seeing now. Okay, so next. Any restriction for short-term travel for green card holders? Could be any problems during entry back for green card holder after 21st January if you're a citizen of one of the 75 countries? No, I mean, when you say any problems, depend what you mean problem. I mean, anytime you're entering the United States, if you are excessively questioned, that I think it's a problem. You have a green card, you should be questioned about the reasons for your travel, and that's it, not because you're a citizen of those 75 countries, which has nothing to do with you being a permanent resident. So in terms of problem, when you enter the United States, you may be questioned more, you may be questioned where you went, but no, I don't anticipate any problem in a way that you will be held or you will not be allowed to enter the US. Also, I want to clarify while we're on this topic, a green card holder cannot be banned from entering the United States. They cannot take away your permanent residency unless you voluntarily surrender it. You sign a form, I believe it's I-407, I forgot the number of the form, where you voluntarily surrender your permanent residency, and they offer you sometimes at the border if they see you've been absent too frequently or for too long, or unless the immigration judge orders that you should lose your permanent residency. So unless one of those two happens, at the border, they may not let you into the United States. Now, there are maybe security reasons and so on, but that also applies to US citizens. So as a permanent resident, you must be allowed to enter the United States. What can happen is, again, not necessarily, Rufus, in relation to your question, but I'm just kind of veering off the topic. As Trump says, I will weave it back into the initial question. So if a green card holder has been absent from the United States for too long, whether it's 6 months, 2 years, and so on, and then they return to the US, people misunderstand. They believe that, I'm not going to be allowed to enter the US. They'll take away my permanent residency. No, the Customs and Border Patrol, they don't have, or Protection, CBP, they do not have authority to take away your green card. The Department of Homeland Security doesn't have authority to take away your green card. And by green card, I don't mean the physical card. I mean the permanent residency status, right? The green card is just evidence of your permanent residency. It's not the document that you see, the green card. Even if it's expired, even if you lose it, you're still a permanent resident. Similar to citizen whose passport expires, they don't lose their citizenship. They just lose the evidence of showing their status, being U.S. citizen or citizen of any country. When the passport expires, nobody gets alarmed and saying, I lost my citizenship. Similarly, the green card, if you lose your green card, or if somebody steals it from you or takes it away from you, don't be alarmed, you don't lose your permit. Similarly, at the CBP, when you enter the United States, if the Customs and Border Protection officer has a problem with your lengthy absence, they believe that you may have abandoned your permanent residency in the U.S., you should have been in the U.S. more than what physically that you have been, or you're traveling too frequently and so on. If they have these reasonable questions about this, or, I don't have the exact number, whether it's more likely or not, the burden of proof, but or probable cause, then they can take away the physical card and they'll give you a notice to appear in immigration court. But they cannot prevent you from entering the United States because the CBP doesn't have authority to take away your permanent residency. And as a permanent resident, you have a right to enter the place of your permanent residence in the United States. So don't misunderstand that. If you're traveling with your permanent residency card, with your green card, even if you lose your green card, you can still return to the US. Even if you spend years outside of the US, you can still return to the US. You're going to have problems if you spend too much time outside of the US that you will have to prove in immigration court. You will have summons to appear in immigration court to prove that despite your absence, you still kept your intent of permanently residing in the US. But they may not let you in. Now, going back to your question, this 75 country news does not have doesn't have that restriction, doesn't have effect on your case. I really love the questions being asked, and I really love doing this. I want to see. Oh yeah, I have time. I can do. Okay, so we'll continue. Right. So let's see what we have. So I had an interview. Now, okay, well, since we have time, I'll also touch upon green card holders traveling in general, especially in the current environment. So if you're a permanent resident, prepare a file, a travel file for you. If you're traveling abroad, in that file, include your tax returns for the last, let's say, 3 years or 4 years, or since the time you became a permanent resident. If you became a permanent resident more than 5 years ago, it's foolish not to apply for citizenship. So let's just say 5 years, right? So take your 5 years of tax returns since the day you became permanent resident. Put those tax transcripts in that file. Put in that file evidence of your close ties in the US, your bank statements, credit card statements, property ownership, car registration. Obviously have your state ID, driver's license with you. Any kind of documents you have showing that you consider yourself permanent resident of the United States despite your absence, because you never know how long you're going to be absent, right? Some things can happen. Or if you travel too often abroad, even if you're not spending too much time during a single trip, carry with you that file. In the current environment, you want to have that so that there is no suspicion that you abandoned your permanent residency, so that when you enter the US, you have less problems at the border with the CBP officer questioning the reasons for your absence or the reasons for such a frequent travel. Many people believe if you come to the US once in 6 months, you're good, you will keep your permanent resident card. No, you're going to have problems, you're going to have issues. So either apply for reentry permit, but even if you do have reentry permit, still put together that file and carry with you. Again, in that file, you can be creative. You can, you're a member in Costco. Take your Costco card with you, and you have Amazon account, right? So you have mail arriving, and so put that and keep that file fresh each time you travel. It is additional layer of protection from those, so to speak, problems you may have when you're re-entering the United States. So as a permanent resident, do create that file, carry with you. If you had any kind of criminal history, arrest, the case was dismissed, get the disposition records and put that in that file as well. Because at the border, when you enter, you will be questioned. The CBP officer, if they do secondary inspection, they will look into your prior criminal history. And if they see you had some kind of arrest, detention, then it's going to take long time. So make sure you have that until they investigate and find out what is going on, what was. And what they're trying to do is not to decide to let you in or not. They must let you in. What they're trying to do when they do secondary inspection is to determine whether you should be summoned to appear in immigration court or not. If you had a serious criminal conviction, criminal case, or if they believe that you've been convicted of that crime, even though it was not conviction, they may issue summons. Then you have a problem. Then you have immigration court case. You have to argue. You have to hire a lawyer. You have to pay expenses, and then have to go back and forth with the court. So carry that file with you. Put that file, create it, and anytime a permanent resident travels outside of the U.S., you should have that. It will make your give you additional assurance that you'll have less problems. And will potentially make it smoother to enter the United States. But again, this is another reason to apply for citizenship if you qualify. There is no reason to have to go through all this. If you are qualified for citizenship, and in most cases you qualify 90 days before your 5-year anniversary of the date on your green card, where it says green resident since. In the cases, if you're married with a U.S. citizen and you have been married for at least 3 years, you can qualify within 3 years of your permanent residency. There is also physical presence requirement, so look at it closer. There are formulas, and that physical presence requirement slides with you, with the date, with the calendar, as you wait for your interview and then off ceremony. So it's complicated formula. It's not, for someone with mathematical skills, you can calculate all that. It's not that complicated, but it's nuanced. So apply for citizenship, though. Apply if you qualify. Apply for citizenship. Don't wait too long. Don't delay it. Don't be discouraged by the recent news and all this chaos in immigration announcements and panic. Don't be discouraged. Apply for citizenship. Apply for any immigration benefit you qualify for. This is the time to do it. You want to protect yourself. You want additional layer of protection. All right, next question. Sir, I had an interview on January 11th. The officer told me my case is under AP. Yeah, AP is administrative processing. I am a DV winner. He also said that I need to wait until the pause is lifted. What should I do now? Do I have a chance? So I assume you're from one of the countries where one of the 39 countries where the pause has previously been placed in December. If you had January, so 6 months from that, you can file mandamus action to force them to make a decision. because the diversity visa-based permanent residency has to be, the immigrant visa has to be issued before September 30th, which is the end of the federal government's fiscal year. So that's why you must push and force. I would file a mandamus action if this was January, but not yet. I'm talking about June, I would say. Well, I mean, there may be a chance for you to file. Again, this is new announcement. We haven't researched on this. There may be a good reason to even file now, considering the irreparable harm if the federal court doesn't order the State Department to make the decision on your case by September 30th, because it's now being settled law that even federal court cannot force the State Department to issue after September 30th, but after conclusion of the fiscal year for diversity visa applicants, because that's the date mandated by Congress. It's for this fiscal year. So if you had interview on January 21st, you can file a mandamus action, and I believe successfully argue that it's not premature because the State Department itself publicly announced that this poses indefinite, right? So the government attorney in the federal court in the mandamus action can come and argue that no, it's premature. We just had the interview. It's not unreasonable. Yes, it would be unreasonable, but what is unreasonable? Not only that you haven't decided this case for this individual who had the interview on the January, what was it, 11 or what? But not only you're not, you're keeping on administrative processing, but you're publicly and affirmatively saying that it's indefinite, that there is no end to this pause. And if this person waits for that unreasonable threshold by June, July of this year, and then files this action, then they will only have very limited amount of time, such as 2-3 months, and to get this processed. And if the case does get dismissed, then you will wait and do it again. If this argument doesn't win, then you will have a chance to refile it again once you get that unreasonableness threshold, which again typically is 6 months after the interview. And if you do that again, then you can file for emergency order. You can ask for the federal government to make emergency hearing on this and issue that order because of that September 30th deadline for your case to be issued. But anyway, I wanted to break it down for you so you have the full idea, but consult with a lawyer if you want to take these actions. Get in touch with us. We'll be happy to help you. All right. Next question. If you are in the US and you have a child and you're from the seven, okay, let me see. I'm sorry. Yeah, I think I skipped answer your chat, sir. Okay, I'll do my best. I'm a US citizen, filed, I'm a firm. Okay, I'm sorry. I skipped too many questions. There are too many. Let's do this. I'll answer for the next 5 minutes, and I'll try to be as quick as possible. Man, so many questions. And I thank you everyone for all these questions. We will have to do this again and go through more. All right. Wow. Okay. Okay. The petition in Peru. How did I skip all this? The petition for my wife in Brazil. Okay. All right. What happened with immigrant visas already approved? Okay, already answered. F1 student inside the US filing EB2 national registration. Where can I still the green card if EB2 is approved? Yes. Again, it doesn't. These news don't affect the processes inside the United States. There's a K1 visa from Thailand. We spoke about K1 visas. I am in Ghana, and my fiance and my baby daughter are citizens of US. I want to know if this will affect again K1. I'll skip K1s because we talked about it very thoroughly. The petition for my wife I-130 in Brazil in the past NVC process, but waiting for the interview appointment letter. Very good that you should have an interview. The interview will be scheduled, but no visa issued. That's correct. You're understanding it correctly, Jake Pulley. So The interview should be scheduled. I anticipate it to be scheduled, and they do schedule, even for those countries, 39 who have been whose visa issuances have been banned since December. We have interviews. We had one interview scheduled earlier this week, actually held. The interview was held, but the visa issuance is paused. Next, the petition I'm doing for my wife. She is in Peru. In the USCIS page, there are no updates on the case. Is there going to be any type of problem with those cases? Well, again, the problem is the end of the process, the pause. But if you already filed petition and it's still pending USCIS stage, I don't think it will affect, because I anticipate this will be decided by that time. By the time it gets to the consulate. Next, hello, Mr. Ismail. Do you advise me to stay home or hide, never opening door until the immigration authorities' arrest campaign is over, or should I continue going to work and risk being arrested? That's very personal question. It depends on the personal priorities, but what you should consider is what you can do if you're approached by the immigration and customs officers. Now, on our website, we have a detailed know your rights post and the brochures in multiple languages as to what to do if you're approached by the ICE officer in the street. What are your rights, and what to do if you have an ICE officer coming to your workplace, or what to do if they knock your door. What are your rights? So review those PDF brochures on our website. If you go to the news section on our website at islawfirm.com, in that news section, you will see that post. I believe it's the second row from the top. Or if you're looking on mobile, you just scroll down and you will see that what to do in case if ICE officer stops you. And look at those brochures. Those brochures were prepared by us with the help of American Immigration Lawyers Association, who provided, the format and information, and we all modified and wrote our information, and all of the members of American Immigration Lawyers Association, in collaboration with each other, posted that. So those are still valid as to what to do or not to do. But as to whether you should go to work or hide at home, it's a very personal decision. I feel the pain. I feel that, and I really hate how people are discouraged from going to work and from living their normal lives, doing their normal chores, whether you're documented or not. You're feeding your family, you're doing work, but that's not something I can tell you. If I tell you stay home, you're staying home, you're not working, then your family's suffering, you're suffering financially. And if nobody would have arrested you at work, or nobody came to your work, then, my advice was wrong. If I tell you, go to work, go do it, don't worry, it's not as bad, and then ICE officers come and raid your workplace, then again, I'm giving you bad advice. So it's not a legal advice, it's more like personal choice. All I can tell you is what is going on now in the country and how to protect yourself in terms of knowing your rights in case if you're stopped. All right. Next question. The petition I'm doing for my wife, she's in Peru, the USCIS page, there are no updates. Is there going to be any problem with those cases? No. It's the I-130. Okay, very good. As I said, no, the petition itself, USCIS page is still going to be. Ismail is the best. Ismail is the best. Wishful thinking. No, the question is, Ismail, is there a best path for F1 student visa application applying from the outside of the US or inside the US while being in the country on a tourist visa? Visa applying. So it depends on the circumstances. Sometimes it's best to do it from outside of the United States through consulate to get the F1 visa, student visa, because then you're establishing good history with the consulate. And down the road, F1 is a non-immigrant visa. And down the road, if you leave the United States, if you need to renew the visa, it will be easier. But at the same time, if you are in some kind of questionable situation, whether your F1 will be denied or approved, whether there is a possible reason for the consular officer to use their wide discretion to deny your visa, then the problem is you're going to be stuck there. And for example, if you qualify for asylum, you have fear of persecution in your home country, and you applied for a visa F1 there and denied, arbitrarily denied even, you're still stuck there. But here, at least then you can apply for some other benefit for which you may qualify or may not qualify, but don't apply for something you don't qualify for. But at least if you have basis for fear from your home country, then you can apply for asylum in that kind of situation and still be able to remain here in the US. Or maybe you qualify for TPS. I don't know where you are from. Okay, next question. Hi, I would like to know if visas are paused. Does it mean I-130 education paused? No, it's not. If the woman planned to marry is already in the US and she's planning or changing her status to get work permission and green card, does this affect that? No, not in the US. Now, if that woman in the US is undocumented and entered the United States without inspection, then it can affect, because if the beneficiary entered the United States without inspection, then they'll have to have a waiver. They have to go through the consulate without inspection, meaning they crossed the border without inspection, just as it says. So they entered, so to speak, illegally the United States, crossing the border illegally. So in that case, they don't qualify for adjustment of status. The only way is to go through the consulate, and the issue visas are paused, so it may affect that. But as I said, it's a very lengthy process to go through that waiver, provisional waiver, and then petition and all that. So all of that takes years. So by that time, it's not going to affect. So theoretically, it does affect, but in practice, it's probably not going to affect your case, because that is going to be resolved by the time the case goes to the consulate. My daughter has her IR2, that's immediate relative to immigrant visa, stamped on her passport. Is she included in the recent ban, or it's safe to come to the America after January 1st? It is safe to come. I've already addressed that. Make sure she enters within 6 months of that date of the visa issuance. Well, before the expiration date, let's simplify it. So look at the visa. She needs to enter the US. And no, that doesn't affect. She should enter as soon as possible. When do you expect the pause to be lifted for 39 countries? We don't know. I would estimate within 6 months, but from the inaction, so that was in December, so I estimate maybe sometime mid-May, or it may go beyond that. Look, I mean, there have been a lot of visa issuances delayed beyond 6 months. There have been individuals historically under Obama administration, Biden administration as well, who haven't been issued their visas for years after their interviews. What the recourse they have is filing a Mandamus action in federal court. So that can happen now. The Trump administration, testing, boundaries of all this, of their, authority, they can do that. They can even continue beyond 6 months. But what I'm saying is that you will have recourse after 6 months by filing Mandamus action. What about I-130? What about, so I-130 is, as I said, I-130 is not affected. I-130 can be filed. It's still accepted. It's being processed. Next, valuable information. Thank you. Thank you very much for your comment. Next, I'm trying to marry an American citizen. She's saying would be safe, but I'm afraid to have kids and I get caught. Why are you afraid to have kids? Well, okay, I understand now. And I get caught and ruin my life and my family's life. Would marriage reinforce my case? Thank you. So, Mohammed, it depends on what status you are in, how you entered the United States, whether you were inspected or not, were you arriving alien or not. I appreciate, I don't know what it means on YouTube. First time I'm seeing, like there is some kind of payment information and so on. But, if you're doing it, I appreciate you don't have to. Again, I'm going through the list of questions, but best to schedule an individual consultation and go through all this in great detail, Mohammed. So it depends on how you entered, what's your current status, do you qualify under any kind of waivers and exceptions for that rule inside the US from being able to adjust your status in the United States. So if you're in the US, you entered the United States with inspection, but for very rare types of cases, such as J1, but again, you can also get a waiver for the J1 with 2-year foreign residence requirement. You can apply for adjustment of status, again, in most cases. But I cannot give you the exact answer, the correct, accurate, definitive answer without knowing all information about your case. So contact us. We'll be happy to talk to you individually. Next question. My wife was issued her visa in November. It is printed on her passport. She will be flying into America January 21st. Resume enter without any issue. Yes, she can. She can enter the United States. She should do it as soon as possible, just as a precaution in case if they, come up with some reason to revoke the visa. But again, it's very rare for revocation of the immigrant visa. They cannot do it on a hunch. They have to have real legitimate reasons, probable cause, so to speak. Many of you have heard of probable cause for arrest, probable cause in terms of criminal enforcement here. Let's call it a probable cause for that. Well, not even probable cause. They have to prove the case to revoke the immigrant visa. All right, next, I am a Canadian. Revoke means canceling the visa after it's been issued, so that everybody understands what's the difference. So the pause on issuance is pause before the visa is issued. The revocation means they issued the visa, now they realize that there is a reason to cancel it, so they're revoking it. It happens frequently with non-immigrant visas. For example, they issue a non-immigrant visitor visa or student visa, and then they find some derogatory information about that individual or school they applied for. Or it happens in the non-immigrant visa context. Sometimes this visitor goes to the consulate, applies for a visa, says, I'm going to go to the US visiting my family or friend for 3 weeks. And they come and they spend months in the US. Many times, unfortunately, the consulates then revoke post factum their visas after they return from the United States, saying, but you told us 3 weeks, but you spent 3 months. Unless you prove you had legitimate reasons, we believe that you worked there or you lied to us. That's why we're revoking it. So for any visitor visa applicants, be careful. Try not try, but make sure you tell the consulate truth as to the purpose of your visit and the length of your plan. It's not about just getting the visa. Even at the border, you may have problems entering. Having a visa stamp in your passport, talking about non-immigrant visas, student visa, B2 visitor. So having those visa stamps in your passport doesn't guarantee your entry. The CBP officer may still cancel. We've been going for 2 hours, 10 minutes. I appreciate everyone joining. I want to be fair to everyone. My goodness, I have so many questions. It doesn't end. I appreciate everyone. I promise if you don't get an answer from me to all these questions now, and you what I want you to do, please post your questions in the comments. I promise I'll go through and try to answer. If not, contact us. If not, I mean, again, I don't want to anticipate, but I'm just saying if something happens, I don't answer, I will. So next question. I am a US citizen, apply for my wife overseas. What happens about new ban? This they affect my application? No, as I said, apply for it now. Oh, since 2024 for my wife. Yeah, so since 2024, that's already a long time. So it may affect, depends if the visa interview is scheduled soon, then it may affect, meaning they're not going to get the response immediately. Next question. Thank you, will contact, thank you. My Jamaican mother-in-law has an immigrant visa interview on March 9. Will this interview be canceled due to the pause by the current administration? I believe Jamaica is covered. I love Jamaica. I go there frequently. I've been not that frequently, but several times. So that's why among the list, it stood out to me as many other countries I saw on the list, but Jamaica was like, yeah, we don't have a lot of Jamaican clients. So unfortunately, Jamaica is in the list. Immigrant visa interview March 9. Unfortunately, it will be affected. It will affect your mother-in-law, and the interview is not going to be canceled. Hopefully, by March 9, there will be some kind of lift by the federal courts of this pause, but nobody knows. So it may or may not affect, but the interview will go on. So next, will there be any effects in J1 visa? No, J1 is a non-immigrant visa, and as I said, non-immigrant visas are not affected, at least by these news. My Jamaican mother, okay, so that's the question. All right, so Jamaican mom, you posted the same question 5 times. Please don't do it, but I appreciate it. Oh, okay, it's too many times you posted, not just 5 times. I'm a U.S. citizen filed, okay. I'm a U.S. citizen filed my I-130 for my wife and child from Azerbaijan in September 2024. All right, it's still pending with USA's ban affects Azerbaijan. Would it apply to my petition? Again, it applies to the decision, to the issuance of the visa, but not to the processing. So everything will go the same way. Now, when I say everything will go the same way, I don't mean that there is no chance that there will be delays in the process and so on. Under Trump administration, things got delayed. The processing of the cases are chaotic and so on. But at least by this news, by this ban, so to speak, at least this ban does not apply to the processing of the case. And hopefully, by the time it gets to the consulate in Tbilisi for their interviews, this ban is going to be lifted. Pause is going to be lifted one way or another. All right. You can't take any benefits for 5 years. No automatic in this regime. TBH. Okay. I am a citizen of okay, again, Azerbaijan. All right. US citizens, it means zero IM experience. I'm not sure what IM means. Constitution, yes. Okay. What about children born in the USA but does not have a passport to parents who were denied asylum? Can the child still get their passport? Yes. So the child born in the United States does have a US citizenship by law and they can get passport. I'm a US citizen. Okay. Good day. I am an Argentinian with an L1B petition visa. Green card process started January 23 with employer sponsorship. My perm date is set December 2024. My wife is from Uruguay. Is she affected? Well, if you're in the US on L1B with your wife, no, it's not. She's not affected. Then you will be applying for adjustment of status. L1B visa, which is intra-company transferee with specialized skills, you have a dual intent visa, meaning the fact that you will be applying for adjustment of status does not preclude you from traveling abroad and returning to the US with L1B visa or even renewing your L1B visa at the consulate. So the visa for Uruguay is not, or Argentina, meaning issuance of the non-immigrant L1B visa in Uruguay and Argentina is not affected by the current announcement or any announcements in the past. Answer your chat, sir. Okay, thank you. I will. I don't know what's that about. I've been on advanced parole or administrative processing since 19 months ago. Should I do WOM? I guess writ of mandamus. Yes, you should. It's my recommendation to do it. I think that, as long as you have good basis, you have a solid case. So doing a mandamus action, writ of mandamus, as this individual abbreviated to WOM, does not guarantee that the case is going to be approved. It not guarantees, but it usually ends with the case decided. So if you have a shaky case with shaky facts and the reasons that the government can pick or deny, writ of mandamus is going to probably have them look at it closer, deeper, and fine. Not always, not necessarily, but yeah. So it doesn't mean that your case is going to be approved as a result of mandamus, but it means that the State Department will be forced to make a decision. Would it be best to apply for naturalization with permanent application, or should we wait for naturalization? Not sure I understand. So you apply for a naturalization and then you wait for the naturalization, and that process goes on roughly about 8 months to 1 year. In some circumstances, in some field offices, it's less. But again, there is no consistency on the current administration that citizenship naturalization applications sometimes take 5 months, 4 months, 6 months, 8 months, generally between 8 months to 12 months. I'm a US born citizen. My wife is from Morocco. Her case is at the NVC center and she has an IR1 visa type. Will this affect? Yes, if she, well, no, she has a visa IR1 already. Well, it's at the NVC center, yes. So anyway, I've been going on for almost 2 hours now. So that's why my speech is becoming slurry. But again, I want to answer all the questions and I appreciate everyone who posted, who clicked like, who's subscribing to our channel. Okay, your wife's case, she's from Morocco, and the case is on NVC. First, I don't remember from the top of my head whether Morocco is in the list. Well, actually, I have the list here. Yes, Morocco is in the list. So since Morocco is in the list, the pause does affect. And the pause doesn't affect the processing of the case, the NVC center. Make sure you provide all the information to the NVC accurately, upload all the information, the DS-260, make sure the case is bulletproof, nothing to pick on. And by the time it gets to the interview, I don't think it will be affecting the case. However, as it stands now, it does affect the visa issuance. If your wife gets scheduled an interview, then the visa is not going to be issued yet. It will be stuck in administrative process until. So once this water is over, that's when I will end. Okay, if you are in the U.S. and you have a child under 21 and citizen, and you are from the 75 countries, will it be hard to get adjustment status from them? FYI, the parent is in the U.S. Yeah, so no, it's again adjustment of status. It's not about being hard or not. Is it applicable? No. Then the news about 75 countries is not applicable to adjustment of status cases in the U.S. to green card cases in the U.S. Now, whether you qualify for adjustment of status as a parent of that child who's a U.S. citizen over 21 or 21 or over is another question, and that is nothing to do with the news, nothing to do with Trump and so on. That's been the law. It has to be closely looked into whether you qualify for adjustment of status or not before applying. There are exceptions. Then, again, entry without inspection, it depends on the time you entered. There has been amnesty, the 245I that applies, that, things that can be utilized for eligibility for adjustment of status. But yeah, look at it closer. F4 family petition. F4 is a sibling of U.S. citizen. So it's family category 4, family priority 4. Got visa, but my country is among banned countries. Will I be allowed to come in? Yes, if you have the visa, you are allowed to come in. Do it as soon as possible. Don't delay. Is it normal for a political asylum interview to last over 3 hours without a translator and then be stopped simply because it was Friday, requiring the applicant to come back again? Nowadays, everything is normal. Whether it's normal or not, no, I don't think it's normal for the asylum interviews to, in general, last years until they're scheduled. But the question is it expected? Yes. Things like this happen, depends on the officer. I wouldn't fight it as long as the applicant is invited to be back within a reasonable amount of time. Unfortunately, asylum is another thing where the officer has very wide discretion to make it easy or hard for you in terms of sending your case to immigration court, so that the court will have to deal with it. You'll have to deal with removal proceedings, extra cost, legal expenses, or they can make the decision on your case at the asylum interview stage, meaning not right after the interview, but afterwards. So yes, things like this happen. I wouldn't fight it as long as, again, they do schedule your next interview, they gather all the information. And when things like this happen, generally it's because the officer maybe had something going on. You never know. Maybe he was traveling or she was traveling somewhere with the family. It's Friday, the long weekend or whatever it might be. You want to, they have a wide discretion, right? So I'm not saying kiss their rear ends, but, be nice to them, they'll be nice to you. Don't pick a fight, okay? Don't pick a fight unless it's really, hurting your case, what they're doing. You've been waiting for years. Asylum is a huge benefit. You applied for it. The U.S. government is considering protecting you from persecution, announcing to the world that you are under protectorate of the U.S. government. That's a big thing. So, yes, sometimes an officer may do something like this to you, but that's not a reason to pick a fight with them. I would appreciate if you answer my question. Thank you, Eric. I hope I did answer. I don't have your question right next to this question. Okay, hi. Is any injection coming from any federal judge? I don't understand what injection means. Oh, injunction. Okay. Oh, I'll be fair. It is injection, not injunction. So, okay, you corrected. Okay, injunction. So injunction coming, nobody knows. Not yet. There is, from what I know, there have been already lawsuits filed, but it's not going to be decided very soon. As I said, one way or another, it will be settled, I believe, my personal opinion, within 6 months. So if one is, what if you already had your interview and been approved, waiting for passport to be returned? So yeah, very good question. That's technical. So that means they approved it. It's all about stamping your passport. The depends on how they interpret the issuance of the visa. So if they already approved, but how do you know it's approved if it's not been stamped? I mean, if you're waiting for your passport to be returned, then they already stamped it. It's just a question of logistics. As I said, it's going to be in effect on the 21st, so you have 5 more days. Logistically, I think you're good. But if not, you have a good argument. If they already stamped, taking it back would be revocation. They cannot cancel it retroactively. All right, next question. If one is an LPR but overstayed, receives an NTA, and also not NTA means notice to appear, and also has an asylum case with USCIS, would the asylum case be transferred normally to immigration court under this clause? That's a very good question. It's very specific, Salman, very specific set of facts. So it's a permanent resident green card holder who also applied for asylum. And that makes sense. Many people don't know this. Asylum gives you protections that the regular green card does not. So even if you have a green card, you can still apply for asylum, get the benefits of U.S. protection, be exempt from public charge. We talked about public charge a lot. You will be eligible for a travel passport, which substitutes your country's passport, which announces to the world that you are subject to the United States, you are a refugee in the US. So that's additional protection benefit you get as asylee, other than just being a permanent resident on other bases. So, but if you receive to NTA, that's a very specific set of facts. Typically, the jurisdiction over your case goes to the immigration court. Now, immigration judge has the jurisdiction, but even though you did receive an NTA, you're still a permanent resident until and unless the judge ordered otherwise. So I believe, based on some other facts that are similar to this, for example, arriving aliens, the USCIS does maintain jurisdiction over your asylum. And I don't think the asylum will transfer. Now, if the immigration judge agrees that you abandoned your permanent residency and orders your permanent residency terminated as a result of that hearing, defending, then you become unlawfully present, and you become you lose your permanent resident status. Now the jurisdiction shifts to the immigration court, where you can ask for asylum, and that in that case, the USCIS will not have affirmative asylum jurisdiction over the case. That's my analysis quickly. If I had this test question during the law school or bar exam, but again, it has to be very closely analyzed. Don't rely on it as a legal advice. I'm just sharing, thinking out loud. Such a case with these type of fact scenarios have to be very analyzed in very great detail. Again, don't rely on someone giving you on the live stream or forum or answer to this specific question, because that's a very, very fact intensive and something that needs to be researched and analyzed very carefully. All right, next question. I plan to submit for my wife. Please advise me. I am a USA citizen. I don't know what you want me to advise. My best advice is go to the online, read the instructions. If you're doing it yourself, my advice is don't do it yourself. Consult with the lawyer, not for the purposes of just consultation. Now, I want to be clear. You cannot consult with a lawyer where the lawyer teaches you how to do it yourself. It's similar to having a doctor teach you how to do a surgery on yourself. Sometimes I do have a consultees, scheduling consultation, telling me, okay, within this 1 hour, tell me how to file for asylum, which forms to complete, how to write declaration, and so on. And I, from the beginning, as soon as I sense that, I tell them, explain this, that not only that it's not possible, but it's also legally is unethical for a lawyer. We can lose license for teaching you to do this experiment on your own by filing on your own to teach you. You can teach yourself. You can review. Again, just like medical services, you can learn how to do whatever you want to do medically on yourself, right? So you want to do a cert, don't do it anyway. It's just hypothetically, but you can theoretically learn. Nobody can ban you from doing any medical procedure on yourself, but no doctor can tell you how to do it on yourself, because you're not a doctor, because you're not a licensed medical professional. Similarly here, we as lawyers. So Don't ask for that kind of quick advice on how to do it. Contact a lawyer if you're dealing with, if you want to work with a lawyer, hire a lawyer. If not, then you'll have to analyze and study yourself. No complaints on that. It's up to you. It's everybody's own decision. Next, my mother from Belarus has interviewed in February in Tbilisi for immigrant visa. Should she schedule or keep the appointment? No. Why would you reschedule? No. Will they keep your passport? No, they cannot. It's always the consulate has a right to keep your passport of your country. They don't have that right. Now they can say that, okay, we cannot make the decision. If you tell them, okay, I want my passport back, they'll have to give it your passport back, and they cannot just, without telling you, keep your passport. But sometimes people do agree to keep the passport if it's not like lengthy administrative processing, if it just takes time to issue the visa, to put the stamp, so that they don't do back and forth. But there is no harm, and they're not going to be offended if you ask for the passport back, saying that I know about this pause, give me the passport nicely, give me the passport, and whenever it's ready to be approved or to be stamped, the consulate will contact you, and they'll ask you to either mail the passport or bring the passport to them. Every consulate has its own rules, procedures. So, there's no harm to ask for the passport. They cannot keep the passport. It's your passport, and they just, I am a DV winner from Zimbabwe, which is on partial ban of those 30, but it is not in 75. Oh, really? So Zimbabwe is in that, but not in 75? Oh, wow. Okay. So I correct myself. So there are some countries which were in the 39, but not 75. I am already in the US. Am I eligible for AOS? Yeah, if you're in the US, you are eligible for AOS. You should apply for adjustment of status as soon as your priority date is up. The diversity visa lottery, go to visa bulletin and follow the priority dates. If you have questions, if you need help, it's a very delicate process as well, especially for diversity visa. You have very limited time. You have to indicate it clearly so they process it before September 30th. Regular adjustment of status lasts about a year of sometimes 2 years of processing. You don't want to risk your chance. If your processing goes regular processing, you have to request expedite. All right. Good evening. I'm a diversity visa 2025. I'm a winner. I'm an LPR since January 2025. So you already got your green card. Filed for a reentry permit in December, did biometrics and left. Will I lose my green card? Live on the US-Canada border and enter often? No, again, I don't think you will lose your green card, but a lot depends on your permanent residency. You're not going to lose, but depends on the circumstances. It depends on why you're there. So length of your absence from the US or frequency of your absences from the US as a lawful permanent resident is just one of the factors. Even if you leave for 1 day and return to the US, and at the border, when you're asked what was the purpose, and you tell the border protection officer that you live in Canada and you're only coming to US to visit, you lose the permanent residency. They'll take it away, call you to court, and then in the court probably the judge will agree that you abandoned. I mean, if you affirmatively stated that you're permanent resident, you live in Canada, but you're just keeping your permanent residence to travel to the US. So there are so many different factors. If you want more thorough, detailed answers, schedule a consultation, whether it's with me or with other competent immigration lawyer. All right, so can an Afghan, we talked about Afghan searching asylum at the border. I have an interview on the 20th of March. Will that affect my interview? I answered very similar question. Yes, if the visa would have been approved right after the interview, and if this pause is still in effect, then it will affect and it will be delayed. The decision. The interview itself will be held and conducted. Hi, I just joined the live stream. He mentioned something about spouse visas and whether there will be exception in that case. No, there is no automatic exception for spouse visas. The spouse visas, which is immediate relative 1 visa, IR1, is affected. The issuance of the visa will be affected, but the processing is still being done, and you can apply and you can file the petition. And most likely, if you're doing it now, filing it now, by the time it gets to the consulate, this issue is going to be resolved. What will happen to my case pending a missing document to be submitted before the visa gets issued? Unfortunately, if you did not submit all of it at once properly, and if something is missing and they postpone and they ask you for additional documents, then it may be affected. The pause will most likely pause the issuance of the visa. if it's after 21st of January. Can I still apply for N400 citizenship of my country's part? Yes, you can apply for citizenship. Zambia, not only you can, but you should apply for citizenship as soon as possible. I spoke about this in great detail earlier. You have helped me so much during this process. I trust your word. Thank you very much. I appreciate your comment. Best attorney in the DMV. Thank you very much. DMV means DC, Virginia, Maryland. Well, DC, Maryland, Virginia. DMV. My fiance, well, immigration law, thank you for your comment. Immigration law is a federal law and it doesn't apply necessarily to this jurisdiction. I appreciate as to best attorney comment, but as an attorney, I want to highlight I practice and our law firm practices immigration law not only in every state in the United States, but all over the world, meaning immigration into the US from all over the world. So no matter where you are, if you need immigration services, we're happy to help. My fiance has a K1 interview on the 20th with the embassy. I've heard this technically non-immigrant, so I'm not sure. So I spoke about K1 several times. I appreciate the question. Next question. We are currently in the United States on E2 worker visa. Very good. That's a small business investor, also known as E2 treaty investor. We plan to switch to EB3 in the near future and start the green card process. Does the new immigrant visa restriction apply to us as well? No, it doesn't apply for the EB3 if you're going to be applying for change of status, adjustment of status in the US. It also does not apply for your E2 visa renewal. It can only apply if you lose your E2 status, you fail to maintain it. So that's why maintain it, make sure you properly extend, maintain your business, and extend your E2 visa, E2 status in the US. It's only given for 2 years. So every 2 years, within 6 months before your 2-year expiration, you need to file for renewal of your E2 status in the US. So make sure you do that, because if you lose it, then you will not be able to go through EB3 process unless you lost it within 6 months. There is 245K exception, but that doesn't, let's not go there. But let's say, assume if you lose for any reason E2 status, or you violated your status and so on, and then your only chance will be to go through U.S. consulate. And if you go through the U.S. consulate on EB3, then this issue or any future issues with the pauses on immigrant visa bans will affect you. So be careful. It doesn't affect now, but it can affect in future. But as long as you remain eligible for adjustment of status, it will not affect you. My parents, who are Russian citizens, just got their green cards in the summer. They're planning to travel to Canada for a visit. Do they need to worry about anything? No, I don't know. Canada is, you need to talk to the Canadian lawyer. We don't, I'm not qualified to comment on the Canadian visa or travel. Does this pose affect O1? No, it does not affect O1. O1 is a visa for individuals or with extraordinary talents who are not permanently moving to the United States, but they're coming here for a temporary project, usually up to 3 years, and then it can be renewed. So O1s are non-immigrant visas. Now, if you're applying for EB1, which is also which is an immigrant visa for individuals with extraordinary abilities, then it will affect. What does it mean? When USAS send the cancellation notice for request for additional evidence? Thank you for explaining everything in detail. I didn't understand the question. So if it's cancellation notice, not cancellation notice. So if they're requesting for additional evidence, then you need to provide the additional evidence that they're requesting. But if that evidence is provided and the decision is made after January 21st and your country is among the 75 countries listed, then your visa issuance will be delayed. I just joined. What about K1 visas? Thank you again. If you scroll back or rewind back, we've talked about it very thoroughly in great details. All right. Should I have a collective lawsuit to challenge the DV pause? I'm a DV 2026 winner. Maybe my case is current. Yes, so there are collective lawsuits that are being filed. The last collective lawsuit was filed in relation to the green card lottery winners who have not received their visas because the administration of Biden stopped processing during the COVID, and then they neglected to even resume the processing unreasonably. Even after the COVID ban was lifted, the consulates was reopened. Unfortunately, most of those cases have been, if not all, have been unsuccessful. The there were some visas ordered issued, but after September 30th, I don't have all the clear picture from the top of my memory, but you should look, and it's called, one of the cases was called Good Luck versus Biden. I don't know why Good Luck. It was probably the last name of one of the winners was Good Luck. So it was a class action case. There was a law firm in Washington, D.C. who was handling those class action cases. I don't want to say that all of them were unsuccessful because I don't have from my memory, all of the details. But look through it. It may be different, especially September 30th is not here yet, and you're diverted to DV 2026 winners, so you still have a chance. So at least the basis on which those class actions have been dropped or negatively decided has not taken place yet. That basis is not here yet. September 30th is still in the future. Next, can you please explain the travel bans? There are some 19 countries and now 75. So there have been 19 countries we had a full ban, meaning ban of non-immigrant and immigrant visas. That's been announced in December. And then 20 additional countries were added for the partial ban, the pause on the issuance of visas. And then now the 75 countries include, and I just learned, thank you for pointing out that Zimbabwe was included in the 39, but not in 75. So, but many of those countries listed in the 39 are included in the 75. But there is an explainer video on our YouTube page, YouTube channel. So subscribe and go through there, and it will answer most of your questions. As you said, you want me to explain the travel ban. So that explainer video explains it. And also, if you rewind this live stream back, you will see detailed explanation in the beginning, but that video is more detailed, more thorough. Mr. Shahtakhtinski, I appreciate your time and work. Thank you for making yourself available. I appreciate all the questions. I appreciate everyone joining and everyone commenting and posting questions. I ask, with your permission, dear audience members, we will pause the questions here. I'll answer the remaining 3-4 questions we have. I appreciate everyone joining. I appreciate everyone commenting, everybody who liked this video and who subscribed to our channel. We will keep updating you, posting updates and providing information, necessary information. Again, don't be discouraged by any of these news, any of these loud panic creating announcements. Apply for benefits, apply for citizenship, apply for file immigration petitions as long as you qualify. If you qualify, you have fear of persecution, you have fear of returning to your home country based fear, then apply for asylum. We do get asylum cases approved. We have asylum interviews frequently scheduled. I have asylum interviews next week. I have asylum interviews and immigration court hearings next week. So everything goes on in terms of cases being approved and the applications being filed. So I appreciate everyone. Please don't be discouraged. Do that. Don't fall into the trap. Don't panic. And if you qualify for citizenship, apply for citizenship. And again, please subscribe to our channel and hit like. I will quickly answer the next 3-4 questions and we will end it there. Join us the week after next. So 2 weeks from now. We may change the time, but we'll announce beforehand what day and time. But typically it's on Fridays at 12:30 p.m. New York time, Eastern Standard Time. So, sir, the pauses for 6 months or more, there is no end as announced, but my evaluation that is going to be resolved within 6 months. It may not be, but if not, then everybody will have, not everybody, but most of the cases, you will have a recourse to file a case. It's expensive. I'm not saying it's accessible to everyone, but still there will be lots of lawsuits. So that's why I estimate within 6 months. Can you explain the difference between the group of countries that are facing 221G that started January 1st to the group 75 that will be starting January 20th? Is neither a ban. So 221G again is administrative processing. It will take too long to explain the difference between the December announcement and now January announcement. But the short story is that in there, the 19 countries had full pause on the issuance of the visas. And here, this is only immigrant visas. But in either case, it's being processed. And 221G simply means administrative processing. It's confusing to other audience members to hear what's 221G. It doesn't help, so we'll say it's administrative processing. It's just pausing the issues of the visas. All right, can I apply for N400 citizenship if my country is one of the 79 banned countries? 75, yes, no, you can apply for N400 and you should. We talked about that in details. I mean, they're traveling to Canada. Okay. Okay, if an LPR got full Medicaid in the, all right, so my EB3 returned to the USA is to be reaffirmed almost over 6 months. Does it affect my case later after NVC returns the case back? I apologize. I keep seeing more questions being posted. I don't know if there is a way to pause the chat, but unfortunately, I am unable to continue this. I thank everyone who posted their question. I will do my best to answer all the questions posted that I've not been able to answer, and I will also do my best to answer any comments that will be posted on this video after we wrap this up. Thank you so much. This by far has been my longest YouTube live stream, and I appreciate everyone joining. Please join us again 2 weeks from now on Friday. We may do more in between now and then. If there are more news, more information, more updates, more hot topics. Thank you so much and have a great weekend, everyone. Bye-bye.